Morning to the assembled multitudes. This is stream 9 of the Wellington Proposed District Plan hearing process. My name's Trevor Robinson, I'm the chair. I'm accompanied by Commissioners Black, Pomare and Mann. We're only accompanied in person by the council team who know where the exits are. So we'll proceed. Ms. Van Haren-Giles, I understand you're number one to go with your contaminated land and hazardous substances topic. And so perhaps over to you. How do you propose to handle it?
Thank you, Chair. Good morning, Commissioners. So just to quickly again introduce myself, my name is Hannah Van Haren-Giles and I'm a Senior Planning Advisor in the District Planning team. So, yep, I'm the author of the Section 42A report for contaminated land and hazardous substances. They're both quite distinct topics with very limited scope of submissions. So for the contaminated land chapter, it's recommended to be retained as notified. And for hazardous substances, there's 3 key recommendations which I can briefly run through. The first being a new definition of hazardous facility, and that's to support the use of that definition in the natural hazards chapter. The second recommendation is the removal of the natural hazard area clause from HSP1, given that natural hazards are addressed in their self-contained chapter. And thirdly, an amendment to HSR3 that major hazardous facilities in the general industrial zone are a RDA instead of a non-complying activity. But that's the extent of the notes I've prepared, but happy to take any questions.
It was HSP1 that was ended.
Yes, so there's a clause in HSP1, clause 2 of that policy had natural hazard area. And given that natural hazards have their own self-contained chapter, I've recommended that clause be removed.
That in your rebuttal?
Yes, it's in response to the submission of the fuel companies, I believe.
Which is why it doesn't appear in my copy of your 2A appendix. Commissioner Pomare, do you have any questions of Ms. Van Haren-Giles?
I do have, I don't have my Morena.
Morena.
I do have 1 or 2 questions in relation to your Section 42A report, primarily. First one relates to paragraph, sorry. Can you hear me? Can you hear me now? That's better. I can hear myself, which is a little bit off-putting, but at least you can hear me. That's the main thing. Paragraph 43 of your Section 42A report refers to the submission from Taranaki Whānui, which seeks an amendment to reflect a partnership or partnership opportunities in the assessment of contaminated land practices and restoration and recovery processes. And down below that in your paragraph 45, you address that by referring to the P3.3, which does allude to this issue. And then you go on to note that there are triggers in the consenting process through the PDP to enable that active engagement where appropriate. So my question to you is, while the point Taranaki Whānui make is certainly alluded to, if we go to that provision, that refers specifically to the protection of mana whenua's significant sites, etc. I'm not sure that it actually addresses the issue that they've raised. And to that extent, I wonder where you've referred to triggers in the consenting process, can you just clarify in more specific terms where those triggers are, what they are, and how they would be applied, and whether they would in fact be applicable where appropriate in relation to the issues raised by Taranaki whānui.
Yeah, so that sentence in the 42A where I've referred to these triggers in the consenting process, that's a reference back to the NESCS, so the National Environmental Standard for Contaminated Soil, which it's the national direction for the rule framework for managing contaminated land. So I guess that's where the triggers would be.
Okay. That was in the national standards.
Yes.
I see. And are they specifically referred to or applicable in terms of the consenting process?
They are, yes.
Okay. So in that respect, there's no need, in your opinion, for any specific reference to those triggers in the context of this chapter.
No, I'd be comfortable with how the chapter is set out in terms of the introduction to the contaminated land chapter refers to the NES.
Okay, thank you. That's really helpful. And just to clarify, how, looking again at the policy itself, CLP3, and obviously there are no rules for this chapter. So just to be clear, for my benefit, how is it intended to implement that policy? And specifically in terms of ensuring that land containing elevated levels of contaminants is managed to protect wai, tapu and sites of significance to tangata whenua.
Yeah, so the NES itself provides or regulates 5 different types of activities on land that is contaminated or potentially contaminated.
Yeah.
And at that point, when a consent under the NES is being processed,
Yes.
The planner could then refer back to the objectives and policies in this chapter, and that would help guide their decision making.
Thank you. Do you think there would be any benefit to just making that explicit through a footnote or an advisory note or something of that nature? Or is it actually maybe mentioned more specifically in the introduction?
I hope that it's clear in the introduction.
Yes, in NES, yeah. Paragraph 2. Okay. All right, thank you.
Just a follow-up question. Does the NES reference involvement of mana whenua in the assessment process?
Not something I'm 100% know the answer to that off the top of my head. Happy to.
Well, I wonder if, picking up on the Commissioner's question, if it doesn't reference the involvement of mana whenua, is there a case to respond to the Taranaki whānui submission to insert specific reference in these objectives and policies? Because as you say, when it's processed, that's what the planner will look at.
Happy to look into that further.
Sorry, Commissioner.
Thank you. Yeah, just moving on to the next question. And that is in relation to okay. In relation to your section 3.3.5 hazardous substances rules and looking at your assessment, and your recommendation, that seems logical, that operational, well, that major hazard facilities should be able to be established within the port zone. And then further down at paragraph 99, you've provided, sorry, over the page at paragraph 103, you've provided the recommended amendments based on the environmental, economic, social and cultural effects evaluation in section 32 report. And in relation to the cultural effects, you've noted there that there are no cultural effects identified. I was just wanting some clarification for the basis upon which you have come to that conclusion. And I'm thinking, specifically about whether any consideration may have been given to potential costs associated with the effects on sites of significance to milding, given that many of these, in fact, the vast majority of them are located within the coastal zone or coastal area, and particularly around the environs of the harbour. Power sites, numerous power sites in the area, and Kumatoto Power is actually probably, I'm not sure whether it would be within, but certainly very close to the port zone. So in that context, could you please just clarify what the rationale is for that assessment?
Yeah, so it's based on my understanding that there are no sites in areas of significance within the port zone itself.
Okay.
And
We should have something to do with the fact that pre-1840 it was all underwater.
It could do, but there are fuller extents of those, which could well extend into the areas of reclamation. But yeah, okay. So that is your understanding. There are actually no sites within the zone itself. Okay. Thank you. I think we've covered that. Okay, so I did just have a couple more broader questions. I know in your, just going to your rebuttal evidence now, your paragraph 10, I think it is, you refer to the HES policy 1, noting that residual risk must be avoided unless avoidance isn't practicable, in which case it would then be required to be adequately mitigated to a level of acceptable risk, I think, or something to that effect. But I note that P1 uses the term possible, not practicable, even though it is used in other provisions of the district plan. And so firstly, I was just wanting to get some clarification from you as to what is intended, what term is intended in relation to this policy, P1.
So it should be, if avoidance is not possible, that's
Yes.
the wording used in the plan. So yeah, a correction to my supplementary evidence.
All right, thank you.
We're just following up on that. The High Court's told us, interpreting policies that talk about what's possible in the context of the NZCPS, that means irrespective of cost. We may have it may be a scope issue, but if the obligation is to avoid irrespective of cost, then does that have implications for the section 32 analysis of relative costs and benefits of implementing this policy?
Happy to go back to the section 32 and have a look at that.
Did the section 32 analysis, in fact, consider, like I appreciate that this is, you don't immediately have, every line of the Section 32 analysis in your head, because I certainly don't, that it might be worth looking, and as I say, it may come back to the fact there's no submission seeking to change it, and so it is what it is. But that would seem to have some reasonably significant implications for the cost-benefit equation. Sorry, Commissioner.
No, thank you for that question. That was along similar lines to the follow-up questions I had. When I was going to pursue some other questions, but given that you've clarified that the correct term should actually be possible in this case, as opposed to practical, there's probably no need to do that. Other than, I guess, just to get an understanding from you as to whether the possible avoiding where possible seems to provide a higher threshold, irrespective of cost, just from a protection point of view. Avoiding where possible as opposed to practical would appear to provide a higher threshold of protection. And so in terms of policy, now in terms of the threshold protection for outstanding natural features and landscapes that are impacted by the development of new infrastructure as opposed to upgrades of existing infrastructure, say, given that the character, intensity and scale of the effects from the new development of infrastructure within those areas would obviously be significantly greater in terms of the effects than upgrading, which presumably would generate similar effects in terms of character, intensity and scale. From a planning point of view, in your opinion, should there be a distinction between those two scenarios in terms of a threshold?
In terms of upgrading versus new.
Upgrading versus
Yeah,
new.
I think that is set out in the rule framework. So that HSR2 rule is for existing major hazard facilities, of which there's only one in Wellington City, which is out in Miramar near the airport.
Right.
So other than that, which to my knowledge is not within any of those areas listed in an HSP1. So it's not within an outstanding natural feature or landscape.
I see.
So if any new major hazard facility were to be proposed, it would be a non-complying activity.
It would be non-compliant. Ah, okay. Thank you. Oh, that's great. To understand that. In terms of just, I think one further question of clarification in relation to the overlays subchapter. My understanding is, and I just wanted to check and clarify with you that I'm correct, that chapter would also apply to the national grid.
It's probably a question for the infrastructure chapter.
Thank you. I'll save that one. No further questions from me at this point. Thank you very much for your report.
Only one question from me, Charles, going back to HSP1. Does this apply to residual risks to people on the site? Where hazardous substances are manufactured, used, stored, transported, or disposed of.
That wouldn't be the intent. That would be addressed under the Health and Safety at Work Act.
You can guess what the next question is. If that's not the intent, assuming the scope, which is a question mark, should the policy say that?
Happy to investigate scope, but
Like, assuming the scope, your view on the merits?
given the definition of residual risk is once other statutory, let's pull up the definition. The definition of residual risk is the remaining risk after industry controls legislation and regulations, including the health and safety work, have been complied with. I wouldn't think that that would need to be specifically addressed further in the policy.
Mr. Black, do you have any questions, Ms. Van Giles?
Still on P1. Can you just talk me through how acceptable level is measured? Where does that flow through in the plan? How's that assessed?
It's probably not something I could explain. It's these policies and the rule framework were developed through consultation with stakeholders like the fuel companies who quite regularly need to assess their risk. I understand that they have like quantitative risk assessment processes that they would use to determine how far that risk is and the effects. So it's probably a question for someone who's an expert in that field, which
We'll hear from the fuel companies, so
Sorry?
we'll hear from the fuel
Yeah,
companies, so you'll be able to ask them.
So the fuel companies say, they might say something, this is how we say, yes, it is. But how does the council know? How does the council in administering the district plan, how does it
so I think
check that?
I think council would likely rely on the Section 88 information requirement through this rule framework that applications have to provide a quantitative risk assessment.
Okay.
So we would be relying on the applicant to provide that information.
Is the guidance in the natural hazards chapter, because I think that refers to acceptable risk.
Is that where it is?
I've seen it, I can't recall whether it's this plan, but I've seen policy objectives and policies that refer to unacceptable risk in the context of like flood risk. And I've always wondered the same question about who decides what's acceptable or not.
Yeah.
But is that in this case, given that the natural hazard chapter is now operative, does it offer any guidance? That might be something else that we ask you to ponder.
Is there a threshold or a guidance or
like flood risk?
Yeah,
to be expressed in AEP. Like 1 in 100 AEP.
Yeah, there's something that because it's fairly crucial matter in the terms of hazardous substances.
Yeah, I don't have. There would be something for the fuel companies. They might be able to answer what it is, and then in terms of how that translates,
if they don't, okay,
how that translates back to the district plan, in terms of a definition, maybe.
Okay, thank you. We'll ask them.
Well,
yes, good morning, Ms. Van Giles. Seems to me that the industry standards and the NES are going to do the heavy lifting on both contaminated land and hazardous substances. So really the plan is dealing with, well, to quote a term, the residual issues.
Mm-hmm.
I've only got two questions, and they are both on hazardous substances. First is the hazardous substances facility definition. Where's that derived from? I presume it's not a national planning standards definition.
No, it's not. I believe may even be taken from the Christchurch.
Okay.
Well, there's a mistake. Who was the right church after all?
Okay. But suffice to say, you're satisfied that it's an appropriate definition, even though its utility is found in a different section of the plan. That's not, the hazardous substances
Correct.
rules and policies don't rely on it, do they?
No, they don't. So it's purely just for the natural hazards chapter that it would apply.
Okay, thank you. And my final question relates to P1. Sorry to come back to that. In your rebuttal, you do opine that it could be an option to split P1 into two separate policies. And apparently Porirua have done that. I should know that. How would that work? Where would the split? What would the split be based on? What would be the two limbs of the policy?
So the split would be hazardous facilities affecting health and well-being of people and communities.
Yes.
And then the second policy to split out would be that hazardous facilities avoid locating in those identified areas,
Yeah.
so those listed areas.
Okay,
So yeah, split it out that way.
but there would still be avoidance limbs.
Still be the same.
Yeah. Okay. What's your view on the appropriateness of that? That's the test for us.
I think it would make it clearer in having those two policies separated.
Is that something you could draft?
Happy to do that.
Thank you. That's all from me.
And presumably if you're only splitting them, that wouldn't have scope consequences. This is just expressing the same thing more clearly.
Correct, yes.
Any more commissioners?
Just one small issue of clarification that's just come to my attention in relation to the rule R2, HSR2 and the section 88 information requirements for applications. The third one Roman numeral 3, dealing with potential risks and effects on sensitive activities and sensitive environments. I was just wanting to clarify whether the sensitive environments would include those, presumably it does, those areas identified in HSP1?
Yes, that would be
It
the
does.
intent.
Okay, thank you.
No more. I think our witnesses just disappeared. We'll have a brief break until Mr. Anderson staggers back in.
Kia ora. Thank you for having me. I'm Tom Anderson. I have prepared some speaking notes. I'm happy to read those out.
Yes, please.
Okay, so my full name is Tom Anderson. I am employed as a principal planner at and the director of the planning firm Insight, and I have been engaged by the district plan team at Wellington City Council to review the submissions and expert evidence received on the suite of infrastructure provisions in the PDP. The decisions that have been made by Council thus far on the PDP through the IPI process have been enabling of urban development. In terms of the hierarchy of planning documents, the NPSUD through Policy 10 seeks to achieve integrated land use and infrastructure planning, and the RPS through Policy 58 requires coordination of land use and development and operation of infrastructure. The strategic objectives of the PDP also recognise the need to integrate land use development with infrastructure, as evident in strategic objective SCA 01, which I have listed there, but essentially is requiring that level of integration, and same with SCA 02. Given this clear direction, I consider that the enablement of infrastructure through the PDP is necessary in order to achieve the desired level of integration between infrastructure and other land uses and to support the decisions of Council on the IPI. The infrastructure chapter has therefore been written in a manner which seeks to implement the higher order documents and the relevant strategic directions of the PDP. This is achieved through an objective and policy framework which recognises the benefits of, the adverse effects of, and the adverse effects on infrastructure, and how infrastructure is integrated with land development. Specific direction is also provided concerning the role of the transport network and how that should function. Amateur radio has also been included in this chapter, although it's not specifically infrastructure as per the RMA definition. However, as directed by Strategic Objective SCA 05 of the PDP also needs to address the adverse effects of infrastructure and manage these by having regard to the economic, social, environmental and cultural benefits and the functional and operational needs of infrastructure. This is what I have endeavoured to do when preparing the chapter and considering the submission points which were raised. The PDP adopts the RMA definition of infrastructure, which I have listed there for completeness. Aside from airports and ports, the matters which comprise the definition of infrastructure are typically linear in nature or are bespoke structures and generally occur in all zones of a PDP, or district plan for that matter. In terms of airports and ports, the PDP has taken the approach of providing special purpose zones for these. This follows the National Planning Standard Framework. The special purpose airport zone has a purpose in the PDP of providing for the ongoing management and development of Wellington International Airport in relation to its site and the surrounding environment. It provides for activities which fall under the PDP definitions of airport purposes or airport-related activities. Likewise, the special purpose port zone has a purpose in the PDP to enable the commercial port to operate efficiently and effectively as a locally, regionally and nationally significant shipping and passenger port and freight intermodal hub, while managing effects on the amenity of surrounding zones so that adverse effects are mitigated as far as practicable and people's health and safety is maintained. It provides for activities which fall under the PDP definitions of port or operational port activities. These special purpose zones appropriately provide for airport and port infrastructure. As such, the provisions within the PDP infrastructure chapter do not provide for airport and port infrastructure that is within the airport or port zones, given it would result in overlapping provisions. However, the infrastructure chapter still applies to the port and airport zones, as other infrastructure also needs to be located within these special purpose zones. Likewise, the infrastructure chapter needs to apply to any airport-related activities or operational port activities which are located outside of the respective special purpose zones. Otherwise, these activities would have no specific provisions within the PDP. The PDP also contains a renewable electricity generation chapter, which has a purpose to provide for development, operation, maintenance, repair and upgrade of renewable electricity generation activities while managing adverse environmental effects. This is similar to, but not the same as, the airport and port special purpose zones. The REG chapter provides specifically provisions for an activity which could occur in any zone rather than specific provisions for an activity which can occur in a specific zone. While renewable electricity generation activities and associated structures are, by definition infrastructure, clarification has been provided that activities and structures provided for by the Renewable Electricity Generation chapter do not need to be considered under the infrastructure chapter. The rules and standards of the infrastructure chapter then follow the direction provided by Strategic Objectives SCA 01, and that they provide for operation, maintenance, repair, renewal and upgrading of existing infrastructure and the establishment of new infrastructure on a district-wide basis. The infrastructure chapter applies to all zones in the PDP. The PDP also has a number of overlays. When drafting the infrastructure chapter, the initial approach was to have a provision which applied in certain areas, but not others, and so forth, which resulted in provision titles along the lines of new masts in all zones outside of SNAs and heritage areas, but within the coastal environment. This type of wording would have been required to be included in objectives, policies and rules. I considered that this wording made the chapter difficult to navigate for plan users, who could always be questioning themselves as to whether they were looking at the correct provision or not. Consequently, the subchapter approach was determined. The intention of this approach is to make it immediately obvious what provisions apply for a plan user considering infrastructure in one of the overlays. It should be noted that should the subchapter approach not be implemented, the same provisions would be required in the infrastructure chapter itself, making it, in my view, difficult to navigate for plan users. It is my view that the subchapter approach lends itself to the E-plan format of the PDB, which is based around the different spatial layers, including overlays. As stated in my Section 42A report, 820 submission points and 295 further submission points were received on the PDP infrastructure provision. Given the volume of submissions received, the Section 42A report provides a foundation as to the approach taken and recommendations made. In making the recommendations in the 42A report, I also considered the evaluation undertaken on provisions in the Section 32 report. In my opinion, the proposed provisions, including the recommended amendments, provide the best method to achieve the objectives, including the relevant strategic objectives of the PDP. As a result of the process through the 42A report, submitter evidence and my rebuttal, the number of infrastructure provisions which remain in contention has been significantly narrowed. In my view, the matters which remain in contentions are whether the infrastructure chapter should consider Wellington International Airport's seawall renewal project, whether the infrastructure chapter should provide for district or regional resource recovery or waste disposal facilities, definitions and mapping of the National Grid subdivision corridor and National Grid yard on planning maps, clarification in the introduction of the infrastructure chapter regarding cross-referencing to the Renewable Electricity Generation chapter, whether trenchless methods are appropriate in riparian margins under Infrastructure Standard 7, whether rules, infrastructure, natural features and landscapes 41 and 44 should include rail reserve alongside road reserve when considering what should be a permitted activity. In relation to infrastructure overlay rule 52, whether allowing infrastructure works over piped hour is appropriately provided for. And in Rule 54, the activity status for customer connections to buildings in heritage areas and the scale of infrastructure within heritage areas. Rule 58 to provide clarity concerning what, if any, works within the National Grid yard should be notified to Transpower. And on this point, I note that Ms Whitney for Transpower has provided rebuttal evidence on this matter, which I have reviewed, and I agree that her wording in paragraph 1.17 of her rebuttal evidence provides greater clarity and recommend to the panel that this be included in an amended version of Rule 58. And finally, Rule 61 concerning if this rule should use the wording reverse sensitivity or incompatible subdivision use and development. In my experience, in light of the need for infrastructure to support everyday life, the provisions in district plans tend to be relatively uncontroversial at the plan making stage, with discussion typically being around if the objective and policy framework is appropriate, what the permitted activity threshold should be, and what the activity status should be for those activities and structures which require resource consent. In my view, given the limited matters that remain in contention, this is the case with the Wellington PDP. I'm more than happy to discuss infrastructure provisions in detail as we go through the Section 42A report. And I just have one more comment to make around Insight and how that company structure works, because I'm sure you would have seen from the submissions from Mr. Horn, who's working for Powerco and for the telecommunication companies, that he also has Insight as his employer. It's a different company called Insight. So I work for Insight Wellington 2012 Limited. Mr. Horn is Insight Auckland Limited. We work together occasionally, but we are two separate firms, and we've had no crossover in this. So all opinions I express are my own. Likewise, we've had Commissioner Dash been involved in the Wellington PDP, who's had no discussion, no control or anything with my work undertaken on this chapter, and obviously he's not involved in this hearing stream in any instance. So I'm happy to answer any questions.
Thank you, Mr. Anderson. Settle in. Might be here for some time.
Oh, I know we're running ahead of schedule, Mr. Robertson.
What I propose to do is to deal with, because you've got two pretty substantial Section 42A reports and reasonably substantial rebuttal to boot, is to work through section by section of 42A, take the lead, and then invite my colleagues to whether they have any questions on a particular section before we move to the next. Then we'll have a wrap up, whether anybody has thought of anything else along the way. So we'll start with the general submission points that you discuss in paragraph 4. First of all, paragraph 64, dealing with airways submission. Question of fact, where are the airways radar installations, and are they all within the airport zone?
I know there are airways installations which are outside of the airport zone. Hawkins Hill immediately springs to mind. And I'm presuming there are airway structures within the airport zone as well, such as the control tower.
And so does that mean that does that require have any implications for how the infrastructure chapter is framed?
I don't think so. As I mentioned in my speaking notes, the airport or airport related infrastructure which is located outside of the airport zone must be subject to the infrastructure chapter. So Hawkins Hill, for instance, I can't recall off the top of my mind whether or not that is designated. I think it is. So that's also an option, but if it wasn't, then yes, the infrastructure chapter would apply to that infrastructure.
The that's all I had on the general submission. Any other questions, Commissioner, on that section? Along dealing with section your discussion about, well, where does the transport, where do the transport provisions go? You're saying it'd be inconsistent if transport infrastructure was dealt with separately from other forms of public and private infrastructure. Well, isn't that exactly what's going on with the airport and the port?
Yes, and there is some context here around consistency with other district plans in the region and the national planning standards approach. In particular, with national planning standards, I think it makes it clear that infrastructure for transport must be in infrastructure chapters, whereas the national planning standards say it's appropriate to have special purpose zones for ports and for airports. So that's how that distinction has been made.
Well, I suppose it's more than appropriate. It directs that it occur, doesn't it?
Has to, yes. Copies have a paragraph reference as well.
Oh, sorry, that's 79.
Thank you. On that split between of the transport chapter and the infrastructure chapter around transport infrastructure, I think the most obvious parallel in my view is around how water infrastructure is provided for and how water infrastructure is used. So the water infrastructure, the pipes, reservoirs and so forth are provided for through the infrastructure chapter, yet there's 3 water chapters concerning the use of those pipes. Likewise, the infrastructure chapter provides for roads, and there's a transport chapter which addresses the use of those roads. Well, wider than roads and everything that comprises land transport.
So the reality is that it's really a choice as to which direction you go in. It's an open choice. You could, like, there are arguments both ways.
There are, yes. The important thing, to my mind, is that the district plan as a whole covers both the aspects which are infrastructure related and the aspects which are use related. I'm comfortable with where we've landed, but likewise I'm comfortable if it was the other way around because of those arguments. It's how they could go both ways.
Just before we move off that, Trevor.
Yeah, of course.
On the basis, or assuming that the panel accepts your recommendation for taking the connections to road provisions across, have you had a discussion with Mr. Wharton?
Yes.
That?
Yes, we have.
Okay. Okay, I must have missed that in Mr. Wharton's 42A, but those provisions that appear on 24 and 25 of your report pages, they should appear in the transportation chapter.
Yes.
Okay. Do you know whether Mr. Wharton's done that?
Well, from memory, yes, we discussed it and
Okay.
they've been included.
Thank you.
Mr. Wharton could clarify that point right now.
Well, Mr. Wharton. What material?
Sorry, can you clarify for me what the?
I'm just wondering, paragraph 82 of Mr. Anderson's report recommends is that the connections to road provisions, and there's one policy and a rule and a couple of standards need to be moved across to the transport chapter with associated numbering changes. And I just wanted to make sure that you had captured that.
Yes, that's correct. I can give you a specific reference if you like, or
Well, you don't need to give it to me right now, but when you present, that would be useful.
that's fine.
Thank you.
Other issue about, cross that you've raised in section 4 at the very end in relation to first gas, saying you don't need a definition for the gas bulk gas transportation network. that mapping negates the need for it to be defined. Understand the point, but I was going to say that it's okay if it's mapped, but do the rules reference the map?
They should. Yes, I'm confident they do. Then, yeah, the gas transmission pipeline corridor has been mapped in the plan.
Thank you. We're going on to submissions and questions. The first question, which I know you're not responsible for, the immediate thing that hit me in the eye when I started reading these infrastructure chapters is that they look very small. They're in a different font to all of the rest of the plan. And for those of us with failing eyesight, this is somewhat problematic. I wonder if we could ask you, when you do your reply, if you could standardize the chapter with the balance of the plan.
Absolutely. I hadn't even occurred to me that that was an issue. Although I have a colleague who sits next to me who constantly reminds me that my screen is larger than his.
Yes, and looking at your recommended paragraph 90, or recommendation, paragraph 98. I wondered about the penultimate line. This isn't what you've recommended, something you've recommended, but the terminology of any infrastructure that is inconsistent with the definition. Is inconsistent the right word? How can something be inconsistent with the definition?
Yeah.
It's either within or without it, but it's not inconsistent with it.
Yeah, so the point that we're looking to make there, or I'm looking to make there, is that other infrastructure, say a telecommunications facility within the port or the airport zone, is subject to the infrastructure provisions, not the port special purpose zone provisions. So inconsistent is not the right term.
Can you, it's not a big point, but can you give some thought and tell us and imply what you think is the right term? I won't ask you to dream it up on the fly, but that was the same point.
Bear with me a moment, please.
Any other questions on the introduction, commissioners? The talking about objective 1 then. Your discussion of additional infrastructure. It occurred to me that there's also an issue about the direction of national planning standards, that there be a separate infrastructure chapter. When those standards use that term, what do they mean? by infrastructure?
The RMA definition of infrastructure. Those planning standards were written previous to the NPS UD, so 2019 and 2020.
And does that have implications for anything that's just tagged on the end? That's not infrastructure as defined in the RMA, because the
Such as, sorry for interrupting, but I'm thinking electrical vehicle charging stations.
such as such as the ones you've tagged on because for entirely understandable reasons you think it's quite convenient that it's the most logical place. But is that then inconsistent with the national planning standards?
I don't think it's necessarily inconsistent, because every portion of infrastructure which the national planning standards say district plan must address is captured by the district plan and the chapter. And then it comes down to a question of is it appropriate to include other structures and activities which have the same effect but aren't specifically provided for. Amateur radio, for instance, although radio communication does form part of the definition, and electric vehicle chargers, which I haven't dug into what exactly the definition of land transport is and whether or not, but it's a bit of a grey area for me. Land transport structures are provided for in that definition of infrastructure. So it was a belts and braces approach. But to go back to your question, I don't think it makes it inconsistent per se.
In terms of objective 2, might be an issue of scope, but is you've focused at paragraph 113 on management, and as opposed to avoid Centre to raise the question open to interpretation with limited assistance. Yes, you're right. Managed is a common RMA term, which allows for a range of outcomes. Should the objective provide more guidance as to what outcome is actually being sought?
Just bear with me a moment while I bring up the objective itself. If I was working my way through a consent application, I would be comfortable. I would know how to work through what managed is in that term, in that objective, which would include the avoidance, the remediation, or the mitigation of effects, and looking at what the benefits and the requirements of the infrastructure are. I don't necessarily know whether I'd go outside of what avoid, remedy, or mitigate is, but likewise I do, as I say in my 42A report, I think managed is an inappropriate term. So I wouldn't necessarily look to make changes to that.
The other thing is, did Centre Board actually suggest what alternative? They're saying it's open to interpretation.
I'd have to go back to the submission. Happy to do that now if you, or I can report.
Well, like if you could just note that to tell us in the fullness of time.
Sure.
Like in your reply. And looking at objective 3, you've said that 121, the objective aligns with RPS policy 8, and therefore you think that shouldn't be deleted. RPS policy 8, of course, deals with regionally significant infrastructure, whereas this is dealing with all infrastructure. And so to the extent this is broader than the RPS, so it's not giving effect to the RPS in that regard. What's your logic?
I was looking at the RPS definition of regionally significant infrastructure and the definition of regionally significant of infrastructure in the RMA, which therefore applies to the PDP, and they are broadly, there's very little infrastructure which is not regionally significant. I'm trying to think of examples. I think they're going to come down to sort of local customer connections, essentially. But I think it's appropriate to have that all-encompassing rather than having a split, say, protect and what there is now in the through the rebuttal, the protection of regionally significant infrastructure from incompatible subdivision use and development. So that direct reference back to policy 8, and then manage the adverse effects, including reverse sensitivity effects of subdivision use and development on the function and operation of other infrastructure. So I have split it, but it captures a very small proportion of overall infrastructure for the other infrastructure proposition.
Okay, Commissioners, any questions on objectives?
Just a follow-up question to that last matter, and it's a little bit of a segue. I note in your rebuttal, Mr. Anderson, that you've delayed addressing the submissions on RSI until the wrap-up hearing.
That's correct.
And the reason for that is that the definition of RSI is something that's being tackled through Plan Change 1 to the RPS.
Correct.
Do you have a feel for the timing of decisions?
I can tell you that. It's 21, the panel's reporting on the 21st of June.
Okay.
Well,
that's good.
Yes.
Okay.
That's an update that I hadn't heard. Thank you, Mr. Commissioner.
Okay. Well, that would seem to work well with that timeframe then.
That works very well with that
Yes.
timeframe.
Okay.
I've also reviewed the submissions that were on that definition of RSI. I don't think it significantly changes what RSI is going to be from what it currently is in the plan. Rather, it clarifies where matters such as incorrect cross-referencing
Yeah.
occurred. So
Yeah, I recall with the review of the regional plan that this was a significant issue and
that was,
resulted in quite a amount of conferencing that I think the chair might have been involved in actually in facilitating. So
yes.
Possibly so.
yes,
And the original the operative previously, I'm not sure how to refer to it now, but I can't remember if you were involved or not, Mr. McMahon in 2013 with the network utilities plan change to the
No, it
Porirua plan.
no, it wasn't. No,
And it caused that definition in the RPS caused some consternation then. So it is pleasing to see that it's being addressed at regional level and,
yes,
as we've learned, important to ensure that the subsequent planning documents accurately reflect it.
yes. Well, I guess it might be one instance where there's a sequential giving effect to. Doesn't always happen.
Mm.
Yeah. Just while I've interrupted you, a point that I missed when the chair invited to comment on the introduction was the point raised by Meridian Energy and Ms Foster about providing some further clarity between the relationship between infrastructure chapters and the sub-chapters. And you've come to the view that you don't think it's necessary, that the red text that you've added in your 42A deals with the matter.
I do.
If the panel decided for whatever reason, belts and braces, that we wanted to provide some further clarification, do you have any comment on where that would go and the wording, or would you be happy to rely on Ms Foster's?
On Ms Foster for that. I think I've said in my rebuttal, I'm not wedded to that position, but in my
Yes, you
view,
did.
the infrastructure chapter is the sub-chapters as well.
Yes.
As I said in the speaking notes, that the reason for those sub-chapters is to provide ease of reading. The
Yes.
provisions would exist anyway if they weren't sub-chapters. They just have different wording to introduce them to say how they fit it in with the other provisions.
Understand that, yes. Okay, sorry to take you back to that.
The other thing is that given that each subchapter says in the introduction that it's a subchapter of the infrastructure chapter, I wonder how many times you need to repeat it.
That's exactly what's crossed my mind, Mr. Robinson.
Might be a question for the Meridian witness.
Okay, turning to policies. C1. First question. Number of policy 2. What are navigation activities?
My understanding is they related to port and airport operations. Matters such to life as you see down, well, not necessarily port, but seafaring. So as we see down on the southern coast, there are poles with a triangle on them to indicate on land above Mean High Water Springs, indicating where the edge of the Tapataranga Marine Reserve is located. Their navigational aids, again, the radar, I think, at Hawkins Hill, at Airways.
I wonder if we should call them navigation aids, because they're not. There's a light and activity.
Yes.
That's section 64 of the former Town and Country Planning Act, Mr Chairman.
Oh, yes. You tell me.
Permitted to navigation aid.
Since you're proclaiming your aids, that you can remember.
No comment.
Permitted
Mr. Anderson's far too young.
permitted a number of navigation aids. There's a right through every district in the council, and it was replaced by section 420, I think, of the RMA. But Airways relied on that provision for a number of radomes around the country that provided navigational surveillance.
We'll check the scope for that, Mr. Robinson, but I will come back to you on that matter.
Other question is way that sub policy 3 is written. Is it only new infrastructure that you're providing for significant upgrades to? That's how it reads.
Yes, I see that. That's no, it should be providing for significant upgrades to existing and the development of new.
So I thought that was probably what was intended, but I wonder if you could think about that. At the policy 2 got coordination. Well have sought to include infrastructure renewal and replacement. You added the words existing and future, so it's both existing and planned use. Created, efficient and aligned. The wondered if that amendment captured that well are making the existing applies to both land use and infrastructure. It's a bit hard that existing land use and infrastructure is integrated if it's not.
Yes, although I think existing land use can be integrated with new infrastructure under that.
So the
Policies.
possibility that I was going to put to you was that you added on the end on an ongoing basis. You're not suggesting that existing infrastructure is suddenly magically integrated, but that's the way it should work on a going forward. Or something like that, to give that impression that that it's forward looking.
Yeah.
Although you're talking about infrastructure, existing infrastructure.
Yeah, I'll just run it through in my head, and I think that's appropriate. Obviously, the intention with the amendment was to make it not just about future land use, but to ensure that existing land uses, and in my mind thinking that was around the densification of suburban Wellington, which has been enabled, is could be construed in existing land use because it's residential activity in a residential area. So that was part of my thinking at the time, but I think the words on an ongoing basis are useful to include in that policy.
Well, as I think about it further, always dangerous to draft on the fly.
It is.
Sorry. Of course.
So I think in your paragraph 147, you talk about the mapping and you raise that in your supplementary evidence as well. But the idea of mapping, I think in the rules zone, there was a mapping exercise done of the national grid as a result of that hearing. National grid was mapped.
The national grid lines are mapped, in the plan in all zones, so wherever they exist, they're mapped. What's not mapped is their subdivision corridor, so they're sort of the,
That's right.
yeah,
Yeah, it was a
yeah,
different thing.
where the effects extend to and what they need to control under the NPS for electricity transmission.
So you'd support a hybrid approach, as you said, in terms of mapping. Then.
I would accept a hybrid approach. I
I
would.
think the mapping's important.
I think the mapping is important in an E-plan format. That
Yeah.
Everything else in the plan that is mapped.
Yeah.
Except for the subdivision corridor, yet it has controls which fall directly out of being within that subdivision corridor. I think it protects Transpower and what they're trying to achieve a lot more if it's mapped, because there's an immediate visual trigger for a plan user that currently doesn't exist.
So you map it, but you also keep the
lines.
Keep the lines.
Yes, keep the lines and map the corridor.
Actually, I think what we did in the rural zone was to do with the acoustic treatment, wasn't it? It was something. It was a separate exercise to.
Yeah, I'm not 100% sure. I can't help you there, sorry.
Thanks. Thank you. Carry on.
And the other point relevant to that is that the way the E-plan works, the whole purpose is that people punch in their address and they get a complete list of all of the overlays. They're the overlays they go looking for.
That's right.
You have to be really keen to go looking in a definition and think just over the boundary.
Yeah. So my example for that, Mr. Robinson, is properties on Old Porirua Road, Naya Gorge, where the National Grid extends above. If you were on a property with the National Grid line clearly went over, you would know that you were to have recourse to those provisions. If you were the neighbouring property, which is within the National Grid subdivision yard that's put forth through a definition, you wouldn't directly know. And I don't think there'd be any trigger for you to look at the provisions in what's now become the National Grid, or recommended to be the National Grid subchapter. So that was kind of my litmus test as to why I think those subdivision corridors from Transpower should be mapped.
I haven't looked at it, but do the rules for that corridor say that the maps are indicative and that the definition is the definitive?
No.
And if not, should they?
No, I've written it with my preference that it's not indicative. That's Transpower's preference. I've said I could accept that, but my preference is that it's more absolute than indicative. I don't understand any reason why it shouldn't be absolute like any other overlay in the plans.
Should it say that in the event of conflict, the definitions prevail?
The definition, the map should reflect what the definition says. It's got a spatial extent.
Well, it should do. Are you confident that it does in every location?
That's a question for Transpower, who I don't think are confident that it's 100% accurate.
That's the message I get from his witness.
Which is where the indicative approach is come from, which, as I said earlier, I think can be acceptable, but isn't the preference given. It would be the outlier from the rest of the plan when it came to overlays.
B5. This is the same manage point. Understand that the objective might be generalised to manage, but isn't the policy supposed to give more direction as to how the objective will be achieved? To me, this is a nothing policy saying manage effects in what way, to what extent, with what end results.
I think P5 and P6 need to be read together. So P5 looks at what the effects on certain areas should, you must consider. P6 then goes into the detail saying how those effects should be managed. So it talks to avoidance, remediation and mitigation through having regard to, and a list of matters which talk back to those earlier or higher order policies, objectives, around integration and recognition of the benefits, and so forth. So it's trying to get P5 and P6 to marry up. P6 does that in a way of, I guess, qualifying what avoidance, remediation and mitigation looks like when you need to achieve the level of integration. So that's I think they work together to give that specific direction.
The other question I had, should P5 reference the overlays? You're saying it's important that there's policy direction within subchapters as to how structures to be specifically addressed. Should it be should convey the fact that there is specific objection and specific direction in the subchapters?
It could do, but it goes back to that earlier point that should somebody be proposing infrastructure in a subchapter, they should be looking at the subchapter policy and the infrastructure policy. And it says that if there's something more specific in a subchapter, then that has precedent over the broader infrastructure chapter policy. I also think policy 6 is referenced as well in a number of the subchapter rule frameworks as to how to reconcile adverse effects.
That comes back to whether the infrastructure, the introduction should say that in greater detail. Does it?
So yeah, the top of page 2, the provisions of the overlay subchapters apply in addition to the provisions of this chapter. In the case of conflict with any provisions of this chapter in a subchapter, the provisions of the subchapter will prevail.
Yes, thank you for reminding me of that.
Just further to that, it's not P5 is not silent on overlays. So clause 4 does mention the identified values of overlays. I guess the question is whether it needs to be any more specific than that.
Or does it need to have it at all? Is the other option, given those specific values are dealt with typically in the subchapter policies.
P9.
Could I just clarify if there's anything you'd like me to take a look at with P5?
Well, like you've given us your answer that if you're comfortable, like I emphasise that there is a certain degree of kite flying going on with my questions, that if you're comfortable with your answer and don't feel the need to take it further, then that's over to you.
Thank you.
I think that you definitely should reply alternative.
I've picked that up already.
Paragraph 9, policy 9.
7 question.
Oh, sorry, P7 question. Come on in, Commissioner.
P7 about reverse sensitivity. So in your rebuttal, so Ms Whitney came back after your supplementary evidence. So I'm a little bit unclear about whether we need that reverse sensitivity in there or not. You're of the mind that we don't.
That's correct.
It's sort of like a commonly used expression, isn't it? It's a definition, and but I also get that it doesn't cover everything.
Yeah. The definition in the plan is, I think, it looks at it in one perspective. The incompatible use and development, which is in the RPS, is broader, but I think encompasses what the definition of reverse sensitivity is trying to achieve.
Yeah.
So therefore, I'm comfortable that the policy 7 is called incompatible subdivision use and development, and through that captures reverse sensitivity, which is now a term which is only directly used in relation to the national grid, and the reason for that is due to the national policy statement on electricity transmission discussing
using those
using
terms.
reverse sensitivity as the term, as opposed to incompatible subdivision use and development on regionally significant infrastructure, which is the
You see reverse sensitivity as a subset of incompatible land use subdivision.
I think it's captured by the definition of reverse sensitivity, and what that's seeking to achieve is captured by the incompatible subdivision use and development, but that's a wider proposition than definition.
Because you're actually changing the whole title of the RS7
Yes.
to encompass it.
But
But it doesn't actually use that term reverse sensitivity subsequently, so that people understand. I'm just, is there going to be an understanding of those two things? I'm not sure, because I'm not.
I think there is, as a regular plan user,
that there is.
That if I see the terms incompatible subdivision use and development, and then I know it addresses broadly reverse sensitivity. But I take your point that just not everybody would have that understanding of what,
Yes, and it does have implications throughout the plan.
Yeah.
Through the rest of the plan, in terms of the use of those different terms. I think the incompatible is clear in its meaning. I'm just thinking about consistency and people understanding.
Yeah, my initial thought after this discussion is that it could be part 5 of the rule, and so it's including by addressing reverse sensitivity effects or something along those lines. But I was going to say managing, but that's the contentious term.
Yeah.
Yeah.
Just a question I had, but
well, let's give you a concrete example. The classic example of reverse, or one classic example of reverse sensitivity, is the residential dwelling establishing next to the poultry farm or the pig farm.
Yeah.
What about the situation, which is where, and so the definition of reverse sensitivity is about incoming sensitive development, putting pressure on existing operations. What about the reverse? We have an existing dwelling and a pig farm wants to establish next door. That's an incompatible land use, but it's not a reverse sensitivity issue, because the later in time is the one effectively creating the problems.
Depends on the zoning.
Depends on the zoning, but that's the scenario where it makes a difference.
Yes.
And the question is, should the plan be providing for that, for the latter scenario, and does it already do that in a different way?
It has to provide for that latter scenario in terms of infrastructure, regionally significant infrastructure, given the direction provided in the RPS. In terms of your example, I think the plan should be providing for that in other ways by managing the effects of those intensive or potentially offensive industries. But that's not necessary, or that is not absolutely an infrastructure matter. It's a land use control within the signs, and then matters such as the discharge odour and so forth. So there's probably some regional crossover there as well. I think going back to the infrastructure, that it must clearly echo the direction that's been set. We've got no choice but to repeat the direction set by the RPS, and that's achieved through incompatible subdivision use and development.
Just before we go off P7, and there's no question here, Mr. Anderson, it's just that there seems to be a relationship between the recommendation in P7 that you've given in relation to, and the changes that you've made, and the, what is it? The issue where reverse sensitivity and incompatible subdivision come up again in INF NG Rule 61.
Yeah, I think it comes up twice.
Yeah, twice, is it? Yeah.
Once is in relation to, and it's been raised by Mr. Lindenberg of Kyong Order.
Yeah.
Once is in relation to that that rule you've just referenced, Rule 61,
Yes.
and that's where I've tried to reconcile it through looking at what the RPS says and what the MPSET says, which is why I think reverse sensitivity must be kept there, because it directly aligns with the higher order document. Whereas the earlier, and I can't recall the reference off the top of my head that Mr. Lindenberg refers to, but I agree that in that instance, incompatible subdivision use and development is the appropriate term.
I just didn't want to lose sight of that this issue might come up again.
No, I'm fully aware of it.
Okay.
Yeah.
Reading your P9, in your logic, so you've got, you're reciting the definition, the direction in relation to the transport network, vehicles, and that includes fins, includes policy supports all traffic mode, no emphasis on one mode over the other. So why does there need to be specific reference to public transport there? Vehicles. That adequate state based on the corridor for vehicles.
It's a width proposition is what I'm trying to capture here. The new roads will need to consider all of those matters depending on what their role, regardless of what their role is in the hierarchy. And it's important that that's set out at this stage when this infrastructure is being developed, because trying to, as people are probably familiar with around Wellington, to retrofit cycle lanes, for instance, or to achieve the desired width of a pedestrian path or a shared path into a road reserve, which was maybe one chain or whatever it was when they was
less than that.
This exactly, or the topography dictates that it's the active carriageway is less than what the road reserve is trying to address that situation up front, so that the road space that is reserved is appropriate for its intended function. So that's where the consideration of all those different modes which will use the road needs to be considered. But it doesn't say that you must provide for one over the other, rather it must be appropriate for what its intended use is, having recourse to those users.
Like policy 13. I was intrigued by your child hinges. If natural character is maintained, why is there a need to minimise adverse effects on natural character? What adverse effects if natural character is maintained?
I think it's a construction activity that can have the effect on natural character as well. So while it may be temporary, it can still have that effect for that period of time. Does that answer the question? I'm not just reflecting on it.
Not sure. I need to think about it myself.
Existing natural character could form under part 1. Existing natural character is maintained.
Man, you have a question?
PT.
P10, yes, go for it.
Stanson, I know there's probably no submissions and there might be a scope issue on PT, but I just wondered whether PT might sit better in the transportation chapter, given that the classification of roads is probably something
That happens after. Yeah, I can see exactly where you're coming from, Mr.
Yeah.
McMahon. The sort of the trigger in my mind is coming back to when you are designing a road, it comes back to that width proposition. So I'm comfortable that it should be here because that's going to be needed up front. So for a new road, that this is going to be our road at the top of the hierarchy versus these roads over here are at the bottom, and they need to be designed accordingly. So I think they need to be classified up front.
But presumably the same works with transportation rules. There'll be rules and policies that relate to the classification of a particular road, whether it's arterial, collective.
Yeah, but in terms of how to connect to it,
Yes,
and so on. Yeah, and I think that is appropriate that they are located in the transport chapter rather than in the infrastructure. But in terms of setting that width, those bones of development, if you like, that it should be in the infrastructure chapter.
okay, thank you.
A really big point, given that Wakatahi New Zealand Transport Agency has rebranded itself. Should there be a global search to align with by its name?
Absolutely.
I say a really big point.
Mm.
Any other questions on policies? Right, stop and have a cup of tea. Thank you. Break for 15 minutes. Be back at 5:11. We'll resume the hearing. Thank you. Mr. Anderson, we're on to the rules. Wondered if in relation to rule 2, you could take me through these in summary form, these standards. Like what are the constraints on new underground structure?
Flick through to those standards to refresh my memory. So standard 2 is about where underground infrastructure should not be located. And that's looking at a natural water body and what the maximum gauge of a gas pipeline must be. Standard 3, earthworks. So what infrastructure companies or providers must do in placing their infrastructure underground. The key there is aside from limiting how long ground can be open to the minimum practicable, is ensuring that trenching is progressively closed and stabilised for no more than 120 metres at a time. S7 concerns riparian setbacks, so it's related somewhat to S2 around no undergrounding below the beds of lakes and rivers. And that should be it. There was some recourse to National Grid Yard, but I think that's been changed.
Yeah, I was trying to think. Like, I was working through those in my mind, and I was thinking, all right, why wouldn't a second Mount Vic tunnel come within this rule? Which standard would it trigger?
I think it would come within that.
So it would
That
be
rule.
permitted.
Mm.
And is that a problem that that infrastructure of that scale is a permitted activity with no, well, like to my mind, there might be one or two small issues that people overhead might be interested in.
I think there would be, Mr. Commissioner. I hadn't that thought hadn't come across my mind. So,
and it may be that there's a scope issue, but I was thinking at a macro level, is the breadth of that rule a problem?
it is in terms of emitting tunnels, which, as opposed to trenches, that in my mind is
just controlling trenches. But if a tunnel were to be driven rather than trenched, like as a second Mount Vic tunnel would be. And so something for you to ponder.
It is, and the other thing I'm pondering right now is around if you left it to trenching, would a tunnel such as the Aris tunnel, which was essentially cup and cover, which is a large trench, be captured as opposed to drilled? I'm also
Well, as long as you had 120 metres.
Yeah. The other, that's right. The Mount Vic tunnel, second Mount Vic tunnel, if it was to be proposed, would also require meeting the standards for new roads. I'm confident it would trigger resource consent. But the aspect around the earthworks, because we've excluded earthworks from having to meet the infrastructure chapter, is an issue that I'll look into.
The answer is yes, there is a problem, but there's no scope to address it. But
I have scope issue question mark written down on my notes.
and just consider the merits first, and then go from there.
Do we? I think just what I'm pondering, I'm just checking through my rules, Mr. Chair. All new roads are a restricted discretionary activity. They have recourse to infrastructure standard 3, which is the earthworks. So
Don't try and figure it out on the fly, because I think that may be the answer for that specific example, but it was more the scale. So for instance, a big tunnel might be driven for a purpose other than a road. I'm thinking of
wastewater.
The interceptor that Auckland Water Care drove under the Auckland Isthmus.
Yeah, or what's being put up Taranaki Street currently.
Well, that's right. And so I think that we need a considered view. If it's not a problem, tell us why it's not a problem, and if it is a problem, is there a solution?
Absolutely.
It's about the breadth of the rule and the scope of the standards that apply to it. Yeah, that was intriguing me. And in the same way, I had a similar question about the breadth of Rule 3 and the effectiveness of the standards to cover things that, so you're thinking when you, my perception of your commentary is you're thinking of day-to-day infrastructure rather than something that is out of the box and might be much larger.
Yes. Yeah, I think I'm thinking of, I'd probably say, higher than 90% of infrastructure. It's that,
customer connections, what's going down the middle of the road reserve.
Yeah. We've covered matters such as reservoirs and so forth. It's that significantly larger projects which really come back to roading.
Well, normally roading, not necessarily.
And then, because I'll come back to you. I'm just sort of going through thoughts in my mind, but as you say, it's better to consider them as opposed to not.
All right, so as I say, could you think both of Rule 3 and Rule 4, Rule 2 and 3 in that regard? Are there sufficient constraints in the standards given the breadth of the activity which is authorised? Yeah, moving from a large point to an infinitesimally small point. I picked up that in 236, your recommended change didn't find its way through to Appendix A.
Okay, I'll amend that. In terms of, I'm just looking at it now, connections, it's the S which is missing, just to confirm that, as opposed to,
That's right.
Yeah.
Hard to see, but that's the only change. Temporary infrastructure. 12 months. This is Rule 6.
yes.
I was thinking in my mind of the examples we read in the media of the Auckland, the works associated with the Auckland Rail, underground rail upgrade, and the plaintive messages of the retailers whose businesses have been destroyed because of the disruption and the to walking traffic by those. 12 months seems seems a long time given in the question. So the question is that too long?
I'm thinking of some more localised Wellington examples, and in particular the new rising main, again going back to Taranaki Street, which has closed off the area on the corner of Dixon and Taranaki for, I think, the best part of more than a year now. And I don't
know exactly what you mean, because I walked past it last night.
Yeah, I'm very familiar with it. It's we're very close to my office, so I'm in that area every day. So that I'm not aware of any similar instances arising out of that in terms of the use of those buildings. I think there's a physiotherapist, a kombucha retailer, and obviously Les Mills gym, as well as some offices. The Auckland rail loop example has been significantly more than a year. I'm comfortable with a year. I think that not only is it the length of time that the temporary infrastructure is in place, but it's also requires compliance with a significant number of the standards in the plan, which are designed to limit effects as well, earthworks, size, and so forth. So, and I also am aware that the 12 months is consistent with other plans around the country as well.
The relation to Rule 7, I was a bit puzzled by your paragraph 251. You say there's no issue by specifically referencing bus shelters, but there's no reference to. So So that what you're saying is like the implication was that was a change, but is that already in the rule?
It's underlined as red and
Oh, it's,
Yeah.
it's
Yeah.
made the change, but not
oh,
been annotated. And
thank you, Commissioner. That explains
That-
it. So
Yeah,
so
Could
the,
have been
the
read.
text should be underlined, but that is a change.
it is. Sorry.
appendix.
Yes.
Yeah.
Just notice that.
Yeah, apologies for not picking that one up. I'm not sure what happened there, but the point being, bus shelters have a similar effect as
Your
those other.
answer to going to 253 that saying that in terms of Wiles issues, they have a problem with the word including because it may not be exhaustive. Now, putting aside airport infrastructure, as you say, their particular problem as it applies to them is resolved in other ways. But what about the general, the saying structures associated with infrastructure, including which means that could be anything associated with infrastructure.
It's intentional that it could be anything. It's in my view, it's not the infrastructure structure. It's the size of the structure which gives rise to its effect. And so any infrastructure structure with an inclusive list, so intentionally not exhaustive, and then recourse to the standards which include size limits. Like I don't see why, for instance, a bus shelter which has a footprint of say 1.8 metres squared and a height of 2 metres should require resource consent when a telecommunication cabinet of the same size wouldn't require resource consent. So I think it's the size as opposed to the structure itself that should be regulated.
S6. So it's S7. That's our riparian setbacks. S14, which is what?
There's 14 links in.
15. Putting the site triangles. Crossings. S1.
Which is health and
If
safety.
size is a critical limitation, why isn't S6 referred to?
S6 is referred to, Mr. Robinson. It is coming back to rule, excuse me.
S7? Oh, no,
It's under
yes,
A.
right. In all other zones, S6 must be.
Yes, so in the rural and industrial, given it is a more generous allowance, and then all other zones in phase 6.
In terms of the vexing issue about seawalls around the airport,
Yes,
are they a structure associated with the airport? So
they are, but they're not infrastructure.
Doesn't matter. The rule is structures associated with infrastructure.
Infrastructure structures is what the intent of the rule is. It should not be structures that are controlled in other ways, such as seawalls.
Um,
The structures that are infrastructure.
like the obvious question is, perhaps the ironic question is that Wiles' submission might give scope to address that. Although I don't doubt that we will hear at length from Ms. O'Sullivan about the appropriateness of doing that in terms of what the intent of the structure of the submission was, but it does illustrate an interesting point that the structures might not necessarily be infrastructure, but in terms of the wording of that rule.
That's right, it is. It's a vexed issue, isn't it? Trying to think of other terms to capture what infrastructure structures are without saying structures too many times is difficult, but I think there's where the line is drawn, and in my view, going back to the Wiles specific issue, is a seawall can be a structure that can protect infrastructure just like it can protect other uses of land, and therefore it shouldn't be considered a part of that land use itself, whether it be an infrastructure, land use, or any other of the myriad of land uses that exist in Wellington City.
A seawall's a structure that's part of the infrastructure, and it just questioning your saying it's not infrastructure.
I think
it's an integral part of it. How is that different from the structure that holds up a power line when the structure is required? It's not.
What?
The structure is required to support that in the same way that a seawall is required to support the infrastructure. You can't have one without the other.
I think it's a wider question. Then I think you could have a structure that supports a line that's then supported by a seawall. And I think this, in using that analogy, it's not. I take the point that you couldn't have the airport without a seawall, but you could have an airport located elsewhere without a seawall. That seawall is a response to where the airport is located. I still think the seawall itself is a structure which can't, while it's integrated with the infrastructure, it's not necessarily a part of that infrastructure. It's a part of a defence or hard engineering measure to protect against a hazard.
Of that particular situation.
In that particular situation, it's protecting A, the road, then B, the airport. In other situations, say for instance, if the one was needed on the opposite side of Lyle Bay for those houses which are on the seaward side of the road, it would be a same hard engineering structure, but it wouldn't be protecting infrastructure. So that's why I've drawn a distinction between what is infrastructure or what assists or protects the infrastructure, because that protection can occur for other land uses.
Okay.
An example is, I saw the light and moved to Hawke's Bay, where there are large numbers of flood banks, some of them which currently have holes in them. Flood banks all around all the rivers. They're owned and administered by the regional council. And you would normally, like I suppose, until I started reading your analysis of what is and isn't infrastructure, you would normally think of them as infrastructure. And I'm trying to think, well, why aren't they in infrastructure? Is it like they're certainly referred to colloquially as infrastructure?
And they don't sit in that definition of infrastructure.
Because I was
the RMA.
I read your speaking notes with interest because it repeated the definition, and I was thinking that
Quite
exact
useful.
question.
Mm.
And so perhaps the answer is that people use the term infrastructure somewhat loosely.
Or the flip side to that is the RMA definition of infrastructure narrows what we should be considering as infrastructure.
That might be true too.
For planning purposes, because, and my mind goes back to the point raised by the Ministry of Education around additional infrastructure in schools and the MPSUD. Now, I don't think we should be considering them, as I've said in my evidence under the RMA definition of infrastructure, yet in a broader sense, I think schools, hospitals, and other sort of aspects of social and health and wellbeing infrastructure are exactly that. I think stop banks can, and potentially even seawalls can come into that conversation, but in terms of what we have to consider with the definitions provided to us, and looking at sort of the broader issues that I've just gone through, that we shouldn't be considering them as infrastructure for the Wellington district plan.
And then going back to the seawalls, they also meet that you said that they meet the definition of hard engineering matters. I was puzzling over this, and it seemed to me they also meet the definition recommended to us by Mr. Jeffries in Stream 6 of airport related activity.
Mm. They may well do, but I don't think that absolves them from having to meet the hard engineering provisions, I think, which are in the natural hazards chapter, given that they're in and correct me if it's changed, but in a separate zone to what the airport zone is. Is that?
Well, that comes back to
considered
the discussion we had at the outset about radar installations that
it does.
are not within the airport zone, but are inextricably connected with its operations.
Yes. Yeah, it does. But I'm still confident in my view that seawall is not a specific airport activity.
Stepping back from it, is the important thing, whether it is or isn't, that it's clear which way, because in its repeated appearances before us, Wiles consistently said they're not arguing they should be permitted, or their renovation of the seawall, but they just want to be certain that there's a clear consenting path.
Yeah, fair enough.
And so from that vantage point, is it more important that it's clear which bucket they fall in than whether they fall in or inside or outside
100%
infrastructure?
The clarity is what the plan should be.
And in terms of what they're trying to achieve.
There should be a consenting pathway. I'm not saying that for
Yeah.
any stretch of the imagination.
But the issue is where that is in the plan.
100% it is where it should be in the plan. And what sort of, should the airport seawall be treated any different to any other seawall which needs to be renewed or established for any other land use activity going forward?
And
the
sorry, Carol.
So the benefit to the airport, I think, probably, I've just as I've thought through it, is if it's in the infrastructure chapter, the functional and operational and benefits of infrastructure, there's those enabling provisions that that need to be included, given the higher order documents come into play. So, but then, is that appropriate for an airport to be able to lean on those where any other seawall wouldn't have that same, well, not any other seawall, because I'm thinking obviously there's the port and the highway on the railway that have seawalls, but for private purposes, not get those benefits. So there's a sort of an issue there to reconcile around equality.
Yeah, well, Weil appeared in Stream 8 and on a belts and braces basis submitted to us, and the reporting officer, Mr. Searle, agreed with them. I'm yet to read his reply, which only arrived on Friday, but at least in his 42A report, or maybe rebuttal, he agreed that the coastal environment provisions should make specific provision for these seawalls. I think Commissioner Black was telling me that they also made submissions that the natural open space zones should similarly make specific provision, and I think the requiring officer agreed with that. So it seems like if it wasn't infrastructure, provided we accept the royal we, because it's not me and Stream 7, provided it's clear those other provisions and we accept the reporting officer's recommendations, it wouldn't matter. So I know that you're clear in your view, while is equally clear in its view that the seawalls are infrastructure, and no doubt they will talk to us at length on that subject. If we agreed with your view, is there a way that you could suggest to us that we could make that determination clear on the face of the plan? Is there room for an advice note saying, for this purpose, the seawalls, Mr. Searle's got a term of art about, I think it's the Moa Point seawall area, but don't quote me. I think that's the term of art is, are not considered infrastructure for the purposes of the plan. Like, I'm always very wary about saying what, inserting what the plan does not do as opposed to what it does do. But in view of the significance of those seawalls to well, I was going to say regionally significant, but I think we could safely say a nationally significant piece of infrastructure, it's really important that the plan be clear where they sit. What's your view? Is there room to
Absolutely. What I'm pondering as well, and I'll give some more thought to it, is whether we don't just limit that to the Moa Point seawall area, but make it broader. So it's all no seawalls are to be considered under infrastructure, but they might have a scope issue there.
Hazard protection works generally.
Yeah, they are dealt with in the hazard protection, like the natural hazards chapter. I'll have a talk with Mr. Searle as well. We have been discussing the issue, so he's cognizant of my point that infrastructure does not include seawalls. So yeah, I'll rekindle those discussions and come back with something that could be useful to the panel.
Because there's well, NZTA are in the process of ripping them up, but there are it's all the hazard protection work down the margins of the motorway. And presumably they're going to replace them on the outside of the shared path.
That's right. Yeah, I understand.
So that would be another example. Comes to mind.
Yeah, the port I know has seawalls around parts of it.
Yes, there's some on the north side of Kaifara,
and on the southern side of the port, between, I think it's
on the edge of Frank Kitts Park, of course.
Yeah, there's there as well.
Passed it a million times.
Yeah, once or twice.
Okay, so that's something for you to think about. Yes. Follow-up questions?
Yeah, I mean, this is intriguing. I mean, it's the first of your 10 unresolved issues, Mr. Mr. Anderson, in your rebuttal. So I've been following it with interest. And I like this suggestion of this further research that you're going to do. But what I think what I heard you say is that you're clear in the view that seawalls are not infrastructure in terms of the definition.
That's right.
I think you did acknowledge that they might play a part in the functioning of the airport in
Yes,
terms of protection of it.
yeah, that was, my point was, I can see why Wellington International Airport would like to regard them as infrastructure to use the functional and operational and benefit type policies.
I guess I just I'm worried a little bit about consistency, and I know the example I'm about to give you is a much more minor example than a seawall in the airport, but in relation to electric vehicle charging stations, you've run the same argument, we run a slightly different argument. You've said that those charging stations are not contemplated under the REA definition of infrastructure, but you accept that they're needed for the functioning of the transport network. And therefore it's appropriate that they're considered at a district-wide level through the infrastructure chapter. It's potentially a different situation to what we're describing now, and you made provision for, we recommend provision for EVCs in the definition or in the rule 7. So I just want to make sure that if we're going down that line, there's not a consistency issue there.
I don't think there is, and the reason for that is the plan provides for seawalls through the natural hazards chapter and hazard protection, and so they're specifically provided for. There'll be no other location that provides for EV charging, and that addition is again belts and braces, because I think there's argument under the RMA definition that structures for transport on land, bicycleways, railroads, walkways, or any other means is sufficiently broad that we could say EV chargers are provided for within that portion of the RMA definition.
Okay, it's just that your wording in your paragraph 49 specifically talks about the being needed for the functioning of the transportation network.
Yeah.
And so I don't want that to come back and bite you. So, well.
Yeah, I think the difference is I didn't want EV chargers to be essentially orphaned in the plan, whereas I knew the seawalls had a home in another chapter.
Well, in terms of consistency, let's talk about the enviro waste.
Yes.
Position, basically non-council waste storage and disposal. Where does that fit in the infrastructure or not infrastructure? Like it's classic wedge.
I know.
I understand why you've included EVs, but where does that take you in terms of your consistency?
I looked at, because I again going back to that broader infrastructure, waste facilities are part of the infrastructure which keeps any city functioning. The RMA definition talks to land transport, as I just mentioned, which I think could include EV charging. It doesn't talk to landfills. No matter how you construe some of those subsections of the definition. I've looked for some other plans as well to determine whether or not they consider landfills under their infrastructure, and typically I couldn't find any that specifically did. So obviously with the municipal waste facilities, they've got the option of designations, and that's what Wellington City Council's done with Southern Landfill, but there's also C&D landfill, which I've had some dealings with over my years of planning, and T&T landfill, and they've worked, well, for starters, the C&D ones within the Southern Landfill designation, which is a bit of an anomaly, but they obviously don't get that benefit. They work within the zone provisions for the plan. I think that is appropriate if a new landfill was needed and it's not in that Happy Valley area, which has zoning provisions which are, generally allow for landfills with controls through resource consent requirements, it would necessitate a plan change. And I think given the scale of effect that can come from landfill and the fact that they'll need significant regional consent requirements as well, that it is appropriate that they be considered on that bespoke basis rather than provided for through the infrastructure provisions.
Place,
That's okay.
returning to the discussion of Rule 10, a suggestion to your paragraph 268.
Yes.
Suggestion of wording for you to think about. I wondered if the and associated support structures should be shifted to the end, because the support structures don't convey either telecommunications or electricity.
Correct.
Okay. Going to Rule 16, getting clarification. Discussed the interrelationship with the national grid, which is dealt with by your subchapter, and therefore the following recommendation is made, and there are no changes in the recommendation. Like, am I missing something? Sort of the implication was that we're recommending some change, but I
think this is an error in my thinking around how any new electricity or net transmission, transpower transmission, national grid transmission, got there eventually, will is to be provided for. I had thought that everything should be placed into the national grid chapter. Then I went back and I've left it here for the very reason that another provider, and I don't know if this exists or not, and Ms. Whitney might be able to help. It might, like Wellington Electricity, for instance, could be looking at or needing to put in lines above 110 kV.
it'd be unusual.
It would be unusual, but I'm not an expert in that matter.
Well, I wonder if I don't think we're shooting to hear from Wellington Electricity.
No.
That you might take on yourself the responsibility of asking them whether there are either any prospect of any lines 110 or greater. Normally they're 33 or at most 66.
Yeah, look, as I say, I haven't really done much work in terms of electricity transmission at all, so I'm happy to take your guidance on that. And
So don't Ask Wellington Electricity.
Oh, in terms of, yeah, in terms of asking Wellington Electricity for clarification.
And then, so if the answer is that the only lines greater 110 or greater are national grid lines, does that mean that this rule should come out and it should go into the national grid subchapter?
Yes, I'm just having a quick look at that national grid subchapter. Yes, it should. We've got rules for new national grid infrastructure within specific overlays, but not for new national grid infrastructure that isn't in those overlays.
R17, new above ground pipelines. Yes. Discretionary. You're saying is if it's addressed in another rule, then no amendment to the rule is required. Relevant rule, I think, is five.
Yes, the customer connection rule.
Should it say, should the title say new above ground policy pipelines not within Rule 5? Because it wasn't obvious to me that if it's covered by two rules, which should necessarily apply.
So FAR 17 could say something along the lines of new above ground pipelines that are not customer connections. Mm.
Paragraph 305. Again, this might just be because I couldn't find them, but I looked in at this rule. You said this should go, R22 should go into the National Grid subchapter, including the changes sought by Transpower. But your Appendix I doesn't seem to have any changes from the notified Rule 22 that I could see. Can you check that, please?
Not a problem. The version attached to my rebuttal
Oh, so that's the answer.
is where you'll find those changes.
Yeah.
It was an administrative error in the 42A proper. The intention was always to make those changes, and it was picked up by Miss Whitney.
Got them. (313) talking about the gas. Gas pipeline. And all instances of the gas transmission pipeline to refer to the network. Your appendix also changes references to the gas transmission corridor, the network. And I wondered about whether that was like, because, well, it's not within this recommendation, and I wondered where the rationale for that was.
We'll have to check that. I don't think that was the intention. The intention was to have the gas transmission network. Let me think, including the buffer area. And that's been provided by First Gas to the council to map.
So what's the definition of?
Bear with me a moment.
So is that in your rebuttal too?
No, it's not. I was reliant on the First Gas submission because I can tell you where the gas transmission network extends from and to, and that it's mapped, but in terms of defining what it actually is, it's not readily identified in the district plan other than as a line on the map.
Maps will include buffer area. I
And-
reread that.
The network, yes. So the location of the pipe and the 60 metres within. So that is the, yeah.
And I suppose the obvious point would be if the gas transmission corridor is identified, that would be a good reason why National Grid corridor should be identified on the face of the maps too.
That's right. Good consistency. And the conclusion I came to, I'm just trying to find it, and I've found it now. First Gas sought to add a definition, and I said, in regard,
you said that wasn't necessary because
of the mapping. Yes,
because I've asked you about that before.
That's
a
right.
little earlier.
Yeah.
So as I say, the thing I picked up was that you changed corridor to network, which doesn't seem to have been
No.
any specific recommendation. And I wonder if you could give us the rationale for that. So it may be the same rationale.
Yeah.
But it seems to be a gap in the evidential trail.
Yeah, I'll clarify that in my right of reply.
Going to 26.
Structures near railway level crossings.
Yes. You may have corrected this in your rebuttal because you seem to. This one with 42A report cross references to S15, and I think it's S13 because the numbers came down and not up. She deleted one.
Yes, should be.
Well, that's me on the rules, Commissioner. Anyone else? Anything detail of the rule? Yeah, that's in the National Grid content.
Yeah. Yeah.
I will go to the S3,
Earthworks.
so that's 339. Mr. Halliday is expressing concern about the trenching limitation, and you've said, well, the utilities seem comfortable with that. So, although you don't put it quite so bluntly, so what's your problem? At least in the case of the telcos and Powerco, maybe the answer is that Mr. Halliday is interested in greenfield subdivision.
Yes.
Covering large areas, whereas the telcos are talking about aren't in that business or not anymore.
Well, I think
Rather,
Chorus certainly
Chorus
are.
is,
Yeah.
but and is Chorus in the telco team?
Yes.
So yeah, so that might be the answer. So
Yes. And on that greenfield subdivision, they would be triggering the earthworks provisions anyway, and I would have sought to, if they can, include the trenches for infrastructure as part of that, rather than retrofitting them in after the preparation works have been done.
they'll do that as a part of their bulk earthworks.
You would assume. I don't know if it always happens, and but I think that's a
We'll put
fair
it
assumption
away.
to make.
They could certainly assume, they could certainly include in their bulk earthworks consent.
Absolutely, they should.
Okay, well maybe that's the practical answer.
Mm.
Reading your answer on paragraph 383, saying the Whakatahi network framework basically is determinative, and I was thinking, well, if the nationally consistent standard doesn't provide for fire appliance access, well, isn't that a problem?
I would have thought so, Mr. Robinson. I think it's important to have that national consistency in the way roads are designed, as we each travel from Wellington to, say, the Wairarapa or Hawke's Bay, and kind of expect the same, wherever it is in the country, expect the same, our roads to look the same, so we are immediately aware of what sort of driving environment we are within.
I suppose my point is, should consistency give way to practical need? Like, do FENS have a point? Like, do the standards adequately provide for fire appliance access?
I can't answer that directly. Is I think it's more a question for a traffic engineer, but I have no reason to think why they would not provide for fire appliance or any other vehicle modes need for access, whether it be a rubbish truck or a private vehicle, whatever it is.
Everybody knows there are some streets in Wellington that don't provide very well for buses.
Agreed. Plenty of people have had yellow paint on the side of their cars. That's come from our buses. However, I don't think the district plan would necessarily rectify the existing situation, but should be avoiding it in situations going forward for new roads.
Have we jumped over S7?
Yes, but fire away.
Sorry, it's just, this is a matter that you raised in your rebuttal at paragraph 35 and 36.
Yes.
And you were hoping that Mr. Horn might be able to provide some visual evidence of this trenching methodology.
Trenchless.
Yeah, trenchless, sorry, yes. But I think, did you say also that yes, you said that you've requested some input from a council expert on this?
I have. I haven't got.
So what paragraph was that? Sorry.
It's 35 and 36. Page
Yes,
numbered.
I haven't had a response to that request from the council officers as yet, other than an acknowledgement that the request has been made. It might be something I could provide in a right of reply after hearing Mr. Horn's
Sure.
evidence as well. But
Have you looked at the wording relief that Mr. Horn's proposed?
yes, I have. But I haven't made any recommendations or anything on it without
You want to
understanding what it is that a trenchless method is and what level of disturbance it may or may not.
You're waiting for Mr. Horn to arrive and
Mr. Horn
and give us greater definition as
maybe some footage.
That's right, some footage,
Yes.
which I'm presuming exists, and also I think it's Mr. Melville from the council who's and part of that, Mr. McMahon, that in terms of, I think I've indicated in my supplementary that I can see where Mr. Horn is coming from, but want to understand it further. And part of my thinking for that was around the where the council officers or experts rather than officers landed for trenchless methods within notable trees, and that was
Sure.
yeah. So
I think you said even if there's some wording relief proposed, then it needs to take account of avoiding root protection areas.
that's right. Yeah.
Yes. Okay. I guess what I was trying to, I guess I was jumping to the chase. If Mr. Horn convinced you, I guess the next question was, what's your thoughts on the wording that Mr. Horn had proposed?
Yeah, I think I generally agreed with.
Okay.
Well, I know I generally agreed with what Mr. Horn was saying, but I just wanted to be absolutely as sure as I could be before making that recommendation.
Okay.
So is this
I've seen that word in other places.
agree in principle, but
That's right.
concerned about the detail.
Yes.
Yeah, I think my concern about that one was about, of course, the points of entry and
Yeah,
exit on those, because that's with any tunnelling, and they're going to go in somewhere.
I know that's exactly.
That's really, even if it's not in the riparian margin, where is it?
That's what
And
stopped
how do you
me.
control that?
It's exactly points of entry that I don't think the works in riparian margin, if you send in some little mole plough through to create a conduit, is the effect. The effect comes from how do you get it in the ground.
Sure.
Yeah, it might be interesting. Actually, Porirua City Council's done quite a bit of work on, not the district plan, but actually on around riparian margins around the Bottomley.
Oh,
In Bottomley Park, in the stream there that they're doing with Kaingora. So
was it?
actually, Stuart, Mr. McPherson would know about that one, but they did a lot of directional drilling there and very sensitive area. It's not without effects. So
yeah, I'm aware of that, but it'd be good to fully understand those effects, and I might confer with my colleagues at Porirua City as well.
Okay, so that's a whole watch the spot pending Mr. Horn's evidence. interested by your paragraph 405, Mr. Anderson. Para 405. It's very precise. So you have provision for a posted speed of 50 or 60, 80 or 90. What happens if it's something else?
This was advice I received from a traffic engineer. I also, without wanting to throw him under the proverbial bus, it's a standard that's been, I think it's been moved to.
There's a lot of roads around Wellington that now have a posted speed of 30k.
Yes, not so many with a posted speed of 70 anymore either, as an observation. Did we change it to?
I think we may have been told in another early hearing stream that Waka Kotahi no longer uses 70.
Yeah, I think that could.
But Wellington City clearly uses 30, as does Waka Kotahi in roadworks area, temporary posted speeds. But Wellington now have large numbers of streets with 30. Yeah, but it says it's got an answer for 60.
Vehicle crossings must not be
Is it?
located.
Might be greater than 70 or less than 70 though. Or basically, should there be a default?
Yeah, it should be an above and below, not a range. But I will have to take in engineering advice and discuss with Mr. Walton. Should be thresholds, not brackets.
In any event, that standard's going across to the transport standard, isn't it?
That's right. Hence why I conferred with Mr. Walton here.
Yeah.
Discuss with the traffic engineer.
So we wouldn't expect to see any reference to 16 then in the rules.
Correct.
Yeah.
Well, you might, depending on numbers.
Of course.
Around, but
We're going to leave that to you, Mr. Walton, to.
Yes.
Yeah, and you write a reply final version.
Cool.
Any question, commissioners, on balanced standards?
No.
In the infrastructure chapter before we move to the sub chapters? Sub chapter report.
Just bring that up. So I'm okay to close.
That's right.
I'm okay to close part 1.
As I say, it's an open book, Commissioner. If you have a question, then tell us about
I don't. Did you?
it. No. So starting with coastal environment. So you said the recommendations, the main infrastructure chapter addresses the amendment sought by Meridian. And I think you've picked that up in your rebuttal, haven't you?
I have, yes.
Okay, so that's addressed elsewhere. Going on to CEP 14.
Bear with me a moment. My computer's decided at a very inopportune time to not open PDFs, so I'll access
Not a problem.
via.
So progressing well for time.
I have it open in front of me now, thank you.
The reasoning in your paragraph 21, saying CE includes urban areas. We had quite a lengthy discussion with Mr. Searle on that question in stream 8, and I'm yet to read what he said in response. For the benefit of my colleagues, the issue was effectively, the discussion was effectively that areas like the Kilburnie Metropolitan Centre are defined to be within the coastal environment, which raises questions about whether a commercial development in the Kilburnie CBD or its commercial metropolitan zone should need to consider issues of the natural character of the coastal environment. Mr. Searle went away to think about that one.
Good.
And you're effectively making the same point.
Yes.
Because this, the defined coastal environment, which I also note there's aside from Horokiwi Quarry, there were no submissions seeking to amend that. Does Mr. Warden have the answer? Are you deferring to your colleague?
No, I was just saying, it's the coastal environment's broad.
Yes. You say it's appropriate to have a policy, and the conundrum we were discussing with Mr. Searle was it's easy to say that the houses on Lyle Bay Parade are subject to coastal processes and are within the coastal environment. It's a lot harder to say the ones 6 blocks further back are, and whereas the former arguably should be considering those issues, it's hard to think of why the latter should be.
Yes,
and how you actually handle that situation. And so what you're saying is, well, it's appropriate to have a policy addressing infrastructure in the coastal environment. Well, certainly is, because of the breadth of the coastal environment.
We have to.
But
yes.
that doesn't actually answer the submission, which is challenging the breadth of a policy that says allow. Like,
I think we have to allow. I don't think in an existing urban area, which is within the coastal environment overlay, it is appropriate for the plan to potentially decline those who are living there the opportunity to access infrastructure or to be serviced by infrastructure. The approach I've taken to the coastal environment chapter is very permissive until you're within areas identified as high coastal natural character or within those coastal and riparian margins. And I also note there's a number of SNAs proposed in the coastal environment as well, which would be subject to those natural character provisions. So it's very much service the existing urban areas that, or and rural, and if the case may be, that are within the mapped extent of the coastal environment in the PDP. If that gets reduced through other herring streams, then my point still stands, I think. But when you're into those higher value areas, then that's when the question should be asked, is it appropriate to have infrastructure located here per se, rather than back to the standard infrastructure provisions for height and so on and so forth, and the balance of the coastal environment?
Well, it's quite appropriate that you've introduced your broader stance. And the broader question I was going to ask is whether the stance you've taken is consistent with the NZCPS for those areas of the urban environment where there are natural character values, maybe not high natural character, but there are still natural character values that the CPS directs be
It
given
does,
weight.
but it also contextualises it around existing development. From memory, I'm just pulling the NZCPS up now. So policy 6, in relation to the coastal environment, recognise that the provision of infrastructure, the supply and transport of energy, including generation and transmission of electricity, and the extraction of minerals are activities important to the social, economic and cultural well-being of people and communities. So
That's right. And the Supreme Court has told us in Port Otago that you need a structured analysis of how to reconcile that provision with the natural character directions. And I suppose
I think
that like I can understand your line of argument, but as I say, the Supreme Court suggests that you need a bit more than there's this, that providing context and,
yes, it does.
and read them together.
I think what a gap in the plan therefore is identification of that hierarchy. So we've got high natural character areas within the coastal environment, and then the coastal environment, which, if, for instance, you've got Fast Street in Lyell Bay, which is in the coastal environment and looks like it could be a suburban street in Karori, for instance, which isn't. There's no necessarily discernible difference. So it's that next tier down of natural character. I think to answer that reconciliation point would need to be identified and have provisions that respond to it. Part of the issue here could be timing between when the plan was written and when that High Court decision came out. But yeah, I take your point that direction from the High Court certainly exists, but I think it's a broader picture than just infrastructure. And once those less than high natural character but not clearly urban areas are known having district plan provisions, including for infrastructure, that appropriately respond. And it may be that you've got that restricted discretionary or discretionary status. Again, I'm just spitballing here, and having a fine grain look at it through a resource consent process rather than a district plan process.
I suppose that then comes back to P14, and at the moment it's completely open-ended, well, completely unqualified.
Yes, intentionally so.
Intentionally so. And so the question is, does consistency with the CPS suggest that there needs to be some reference to coastal natural character where it exists? Because clearly in the middle of the Kilburnie metropolitan centre, there is not a lot of coastal natural character. So that's the big picture question I'd like you to ponder.
Thank you.
And clearly, in terms of what you talked about, there is a context. You're in an urban environment. People are entitled to get urban infrastructure. But is it absolutely open-ended, even in those areas where there is genuine coastal natural character, although albeit not of high natural character?
That's right. Does there need to be a restriction? I still think those dwellings that are within those areas that have displayed a degree of coastal natural character.
Yes, they're buried under sand every time there's a southerly.
Yes, a lot of work to do to clean out those pipes that are serving, providing the infrastructure in the first place. But I think the point still stands, and looking obviously NZCPS and policy 6 there.
I think what I'm looking for in your reply is a reasoned analysis that if you maintain the position that this is appropriate, why that is, because I think that given the national direction we're working with, we need to be quite careful about how we work our way through that.
Yeah, certainly appreciate that.
This is a P16. I've seen this in other places, reference to commercial zones. There is no commercial zone anymore in the PDP. Should that be centres zones?
Bear with me a second. Let me look at district-wide matters. The plan in its drop-down menu still refers to, as a heading title, commercial and mixed-use zones, encapsulated in that a neighbourhood centre, local centre, mixed-use, metropolitan centre, and city centre.
Well, so if you're saying commercial and mixed use, sort of can't have it both ways. If commercial includes mixed use, why is mixed use addressed separately?
Yeah, I see the point, and looking as industrial or commercial use. But I think that's a wider plan structure question that possibly should be addressed in here in stream 10, where if there's recourse to what currently is shown as area specific matters and under the drop down in the plan of commercial and mixed use, I completely take the point and think, yes, maybe it should solely just be mixed use or centres or some other type zone. And we'll have to have.
It needs to be addressed on a plan-wide basis.
Yes, and that might
up here.
Yeah, and that will probably fix that. Well, that should fix this issue. I'm just trying to think if there's a national planning standard.
I think they call it the national planning standards call it business, not commercial, don't they?
No, they do call it commercial and mixed use zone
Oh,
chapters.
well, 11.
So. It's like you're reading my mind. For completeness, Mr. Robinson, I've got the planning standards here in front of me, and commercial and mixed use areas, part 3 area specific matters of a district plan must include commercial and mixed use signs as the header, and incorporate neighbourhood centre, local centre, commercial, large format retail, mixed use zone, town centre zone,
So
metropolitan
the
centre,
answer
and
is it's
city centre.
consistent with.
So it's
the-
consistency with NPS,
So it's consistent with the
national planning standards. Yeah.
Um, discussing upgrading P20, upgrading, and you're talking about operational need. A bit unclear where this come from. My recollection is that the CPS doesn't talk about operational need; it just talks about functional need. So where did operational need come from?
Operational need is a defined term in the PDP.
Say again.
It's a defined term in the PDP, operational need, and the definition in the PDP immediately reflects the definition. I think it is in the planning standards. There's a planning standards definition, as is functional need.
I suppose the question is, in terms of higher order plan direction, where did the direction to have regard to operational need come from?
It comes from the strategic objectives of the PDP itself. I think it's SCA 03 from memory. But yeah, it's not a term that's used in the NZCPS. Functional need is the term that's used in the NZCPS.
Is the term used in the RPS at all?
No, I think they use operational requirements in the RPS. I'm not sure if change 1 to the RPS is looking at amending that term to operational need now that it's a planning standard definition, noting the RPS was a 2013 document and the planning standards are 2019.
Did I read in your in somewhere in your reports that you someone suggested referring to operational requirements, and you said because this plan uses operational need and therefore you should continue to use that.
That's right. Yeah, that was a centre port submission point.
Gotcha.
You deal with it in your rebuttal also at 118 in relation to, I think might be Transpower, Ms. Whitney. And there's the third leg of the trifecta there, technical constraints. So functional, operational and technical.
Yes.
You said that the PDP defines functional requirements and operational, but not technical.
That's correct.
Okay.
While we're talking about that, the question I was going to ask you in the context of that rebuttal was, when would a technical requirement not be an operational need?
I think they'd be interchangeable, to be frank. Then it becomes back to the NPS ET. Yeah.
see if she can come up with any. Because my inclination, if they're interchangeable, is why would you add?
That's right. Yeah. So I don't know enough
Okay.
about it, but it's, yeah, it is policy 3 of the MPSCT.
Yes. And that's come through in your recommendation on P59 later on.
Yes, for that higher order document alignment.
Okay. In terms of the discussion we had earlier about framework, board framework about of coastal environment provisions as planned vis-a-vis the CPS, explain to me the logic of P21 upgrading of existing infrastructure within coastal and riparian margins, again without qualification, whereas within high coastal natural character areas it's an only allow provision, but open slather within coastal margins.
Open slather within limitations, and that upgrading is defined. I don't think it adds any substantial differences in terms of effects on the coastal environment, riparian and coastal margin. And so we're not permitting the upgrading of or allowing the upgrading, swapping say a pole for a tower or a lattice structure, but recognising that if there's existing infrastructure in those margins, and that as technology advances for infrastructure providers, they'll need to upgrade them from time to time. Likewise, in the coastal environment, they might be subject to harsher salt spray, for want of a better term, and so they will need to be upgraded or swapped out, and maybe on a more frequent basis, but recognising the fact that they've been allowed to establish there in the first place. I can. The improvement or increase in carrying capacity, operational efficiency, security, or safety, but excludes maintenance, repair, and renewal.
Does that have connotations as to the scale? Because, like, at first blush, it didn't seem to impose many limitations.
No, it hasn't got anything in terms of scale there. I'm just looking at the rules now in terms of permitting upgrading. Don't have recourse to policies around sizes.
Like the point being that this is policy, which by definition won't.
No, but the related rule should.
Yeah. suppose if the related rule does, then maybe the related rule is not consistent with the policy.
So in the parent chapter or the infrastructure chapter, upgrading is subject to standards 1, 3, 4 and 12, which is why I was thinking that the upgrading occurs within limits. So that's earthworks, and there's a specific upgrading standard about the upgrading must occur. So the example I gave before, a pole must not be replaced with a tower. The diameter must not exceed twice that of a replacement structure at its widest point. Tower upgrades that must not exceed the width of the existing tower by more than 25%, and so on. So that's the limits I was referring to. That hasn't come through under INF CE, whatever it is that's related to that policy.
I suppose that's the obvious point, that
Yes.
if the CE subchapter is
INF.
code, then
Yes. So INF.
that's a problem.
That is a problem. Must have cause.
So that's for you to ponder.
Yep.
I suppose in relation to the broader question about qualifying broadly frame allowing policies for natural character outside, perhaps you could just note, take a note to include in your consideration of that issue CEP 24, which is new infrastructure within the coastal environment outside identified areas. And this is your response to Greater Wellington's submission, suggesting that there should be effectively a policy paralleling CPS policy 13.
Yes, and my consideration there has been back to the point of how the coastal environment overlay has been set up, which we discussed earlier, which has those high areas mapped and nothing else to differentiate between the highly urbanised and the balance of. So I'll address it in that same matter.
P25 is the opposite issue. You're talking any significant adverse effects are avoided and other adverse effects are avoided, remedied, mitigated. Should those references to adverse effects be related back to coastal natural character values? Because at the moment, there'd be any adverse effects of any kind.
Yes, I think that would make
And
sense.
and you've used that frame of reference in other policies. So it's in P23, it's in P20. So the same question might arise. Going to the rules, the related the related point we were discussing. See, R30, upgrading is permitted without.
Yes, that's the one that needs the recourse to INF S4.
Right, so you're onto that.
I've captured that. Yes.
And same point rises in relation to 33.
Yes.
Looking at CEP 26, broader question about structuring, about the subdivisions of the subchapter. I wondered if it would make more sense if all of the policies were together and all the rules were together.
Yeah, it sort of takes you by surprise that you come across more policies when you turn over the page from those rules.
Yeah, that particularly now that it's no longer the national grid and the gas transmission network, it's just the gas transmission
That's
network.
right. I had thought whether it was even necessary to have separate policies just for gas transmission, and wasn't certain of the scope to combine them all together.
I think that shifting them around within the chapter without changing what they say would surely be a minor change.
Yes, I don't think that. No, I was thinking whether or not we could remove those
Oh,
additional
remove them
policies
entirely. Well, yeah, that might be a bridge too far.
But
I suspect that First Gas might have a hernia if you took out the provisions that are specific to their operations.
that's right. Yeah, so that's what stopped me from doing it. But questioning why, or knowing why we did it in the first place, why it was done in the first place, but then questioning, is it still relevant if you take the national grid out? And I landed on the point you've just raised, and that, well, there's no scope, and
And they're bound to be concerned.
Yeah.
The One question I had though, and the answer might be about scope. Namely, there is none. You look at the infrastructure provisions in P14 and P15, they draw the distinction that you've emphasised between what's inside high coastal natural character areas and what's outside. But P26 has both, doesn't draw that distinction. Is that because the gas transmission network doesn't go anywhere near
That's
high coastal natural character areas?
currently it doesn't, correct. But I have no scope to remove the policies. I've taken advice on that too. So my understanding is that each of these policies and the subsequent rules, now that there's no consideration of the national grid, are orphaned, and that I have no scope to remove them. But then
So what you see is what you
they
get.
aren't going to be used. Yes.
Okay. The I suppose the other thing is there any part of the gas network that's within coastal margins?
No. Gas transmission network. Gas network overall. The gas transmission network, just to be absolutely certain on that's what this.
Yes, that was like the basically the first gas network.
Yeah, the first gas, not the.
Because PowerCo have made the point that they have gas lines.
That's right.
In the
Distribution network as opposed
yeah,
to
in the distribution section. Suppose I should ask you the follow-up, I think I know what the answer to this is, but for the record, is there any prospect that that's going to change, that there will be expansion of that national gas transmission network?
I think that's a very good question for first gas. I have no idea what their proposals may be. Their existing network is a long way from the coast.
The related question, you recommend deletion of P32, which means that you are not providing for new gas transmission within high coastal natural character, or that'd be in indeterminate activities.
No, they wouldn't. I don't think.
Or would they fall back to the infrastructure provision because there wouldn't be a
That's right. There's no conflict in between the
yeah.
and I had scope for P32 through the through the Transpower submission to be able to remove that whole policy. But they weren't so forthcoming for those earlier ones.
But on the assumption that may or may not be confirmed by First Gas, that there's no prospect that it will in fact be any material new gas lines of their network, then that's probably not an unsatisfactory outcome. That there is a rule, would fall back on the general.
That's right.
They don't need a specific.
They don't need. That's right.
Among the rules where you think about the need for a test of what is an upgrade, you might add R36 to that list.
Yes.
Which is the gas pipeline. Your discussion of R38.
The upgrading of existing gas transmission within the coastal environment.
And say there are no existing ones.
That's right.
Would it be appropriate to delete the rule as a minor change if there's nothing it could conceivably apply to?
Is there scope to do so?
As a minor change under clause 16.
I will consider that. As I said, I've had a look at scope for all of these rules relating to the gas transmission network.
Well, as I say, where it could have substantive effect, a substantive constraint on First Gas's operations, that clearly wouldn't be a minor effect. But if there is no existing line to be upgraded, it doesn't seem to present a problem. But for you to think about. So that's all me on coastal environment. Anything else, commissioners?
2 questions.
2 point, yes, carry on. Go for it. Yes. So I about to move to natural features of landscape. Pick up anything before then? Well, on that happy note, we might stop for lunch.
Thank you.
Thank you, Mr. Anderson. Going well, and we will resume at 2 p.m. We'll resume the hearing. I think we're up to natural features and landscapes subchapter. Thank you, Mr. Anderson. First, another stunning point. In your section 42A version, I haven't checked if you've corrected this in the revised P39.
Yes.
If you read sub point 1, grammar police would suggest that it should be are, not is.
Associated earthworks and vegetation removal are of a scale that maintains or restores. Am I on the
No, I
same?
mean, this is new infrastructure within identified ridgelines and hilltops. P39.
Yes, sorry, I'm with you now. The revised P39 was P46. Just to confirm.
Oh, you got a electronic master version.
I have. Yes.
So I'm looking at new infrastructure within identified ridgetops and hilltops.
Yep.
Number 1.
Absolutely. I have not corrected that, and it needs to be corrected.
Thank you. The next, looking at the numbers changed. The sole zone, the sole standard related to earthworks in the subchapter.
Yes.
Oh, yes. You've retained 1A, which is per transmission line support structure. If the National Grid's all gone into its own version, is that still relevant? Or is that pulled in by cross-reference?
I will need to double check that and come back to you if that's okay. Intuitively, it shouldn't be in here, but I'd like to make sure if that's okay.
I had on national fishing, that's anything. I'll
Kia ora, Mr Anderson. Oh, aloha mai.
I'll let you argue it out.
Wait, Commissioner Pomare first.
Okay, right, good. Kia ora.
Slow down.
Thanks very much for your report and for your responses so far. They've been extremely helpful. Just going back quickly to the NFL P38 policy that you discussed briefly with the chair before the break. And I know the context of that interchange was around whether there might be scope to remove the policy entirely, given that there's no existing infrastructure within outstanding natural features and landscapes. But I was just wondering whether, in your view, there may be, it might be contemplated over the life of the plan that there would be a need for infrastructure to be established, first of all, I guess, within areas of outstanding natural landscape and features, and then, you know, the need for upgrading of that infrastructure.
Certainly. Can I just clarify? I think if I recall the discussion about outstanding natural features.
The final policy of the CE.
Yeah, was coastal environment, and it was in regard to natural gas only.
Your one was, okay, sorry, I must have
But that's fine.
misunderstood which policy you were referring to. Okay.
Fine, and for the record, I completely agree. I think it is important that there is an upgrading provision in the NFL, the natural features and landscape subchapter, for that reason. And I'm trying to recall if there is, and I'm confident there is existing infrastructure within outstanding natural features and
Thank you for
landscapes.
clarifying that. Yeah.
I think the Commissioner's questions about the coastal environment chapter that we were talking about just before we broke.
Yeah, it was, but
And so my question was there ever likely to be a new gas transmission infrastructure within high coastal natural hazard character or within, and then there's upgrading of existing gas transmission. It was 37. It was upgrading, it was 37, previously 38. R38. Now R37. My question was, well, for existing, how can there be an upgrade? I think it's going to be the three-card trick. First establish, then upgrade.
Yes.
First upgrade, then becomes existing,
Then it needs to
then becomes upgrade.
And I think we talked about needing to ask first gas the answer to whether it's something that needs to be contemplated. If they are contemplating gas transmission in that area, then yes, the policy would be useful for when it comes to upgrading.
So the answer is it'll be dependent on first gas.
That's right.
If first gas say there is no possibility, I've never yet seen an engineer that says no possibility of anything, but
how much money have you got to play with?
But there's a first time for everything. But so if first gas say there's no possibility, then the reasoning stands. But if they say it is possible, the Commissioner's right that both the new one and the upgrading one should stay because they could happen in sequence.
Yes.
Got
this.
Commissioner Black.
Oh, sorry.
Another one. Oh, sorry.
Keep jumping ahead.
Oh, sorry.
We might not be onto these ones yet then. Am I jumping the gun with the NFL?
Possibly. What are you interested in?
Policy 38, NFL.
Yeah.
Okay. So So back to the conversation we started to have, but
Yes.
then got confused with the previous one. But we were able to kill two birds with one stone in a sense. In your rebuttal, you refer at paragraphs 42 and 43 to the recommendations you've made to amend policies, 30, 38 and 42 in response to Mr. Horn, I think.
Yes,
The
about the
request that he made, yeah.
the respecting or the protecting
Yes, to
versus
change the
respect.
wording from protect
Yes.
to respect. And I just wanted to get an understanding from you as to, I guess, first of all, is it your understanding that these policies have been developed on the basis of a hierarchy approach?
Yes, they have.
They have.
Yes,
Okay.
and hence why I'm comfortable with Mr. Horn's submission that it should be respects rather than protects, because respects is the word which is used in the RPS. So it follows the
Yes.
hierarchy. So
Okay. So it's used in the RPS, and I can see the relevance of it in that sense. In terms, though, of the avoid directive that underpins the provisions, these provisions, do you think that respects goes far and well, that respects actually achieves the objective of avoiding in the first instance?
yeah, I think it does, because the wording is only allow for the upgrading.
Yeah.
That respects. So only allow for the upgrading of existing infrastructure that is located outside an existing legal road and above ground within outstanding natural features and outstanding natural landscapes,
Yes.
where the activity is of a scale that respects the identified values described in Schedule 10. So the only allow is constrictive, for want of a better term, constrains what can be done. The respects, I think, as opposed to protects, goes back to those higher order documents, including the RPS,
Right.
around the recognition of the benefits of infrastructure, which I think it changes that weighting of protect or avoid to you must
Right,
consider
so
it in this context. So it gives a pathway that otherwise wouldn't exist, but still requires the applicant to have recourse and the council to, is this within, does it respect those values? And the values are listed as well, obviously, for each
Yes.
ONF and ONL, and it's got those schedules. So
Can I follow up?
Mm.
So if we're talking about higher order direction,
Yeah.
shouldn't we be having regard to section 6B,
Yes.
which directs us to recognise and provide for preservation of ONFLs and their protection from inappropriate subdivision, use and development?
so it comes back to what's appropriate or inappropriate in that regard.
Which King 7 says what is appropriate is something that protects those values, which gets pretty circular.
It does.
But if you're talking about going back to higher order direction,
I think section 5 probably has a role to play as well in terms of what's the purpose of the infrastructure and around social, economic, cultural and environmental well-being and health and safety.
And section 6 matters.
you could get into a deep philosophical,
Yeah,
Very deep
good.
philosophical.
analysing King 7 about whether you can read down section 6 by reference to section 5. I thought that was what all the stuff about broad judgments was about, and which the Supreme Court have effectively canned as an option.
Yeah, and trying to reconcile with the RPS as well, which is clear on that respect as opposed to protect. And it's about the scale of what the upgrade includes. It's we've got to recognise that it's about existing, and it's not for proposed new
Well, I was going to ask you
infrastructure.
about that too, whether
Mm.
that, because there's no distinction at the moment. Whether we choose to go with protect or respect, there's no distinction between the protection threshold that's used in relation to upgrading existing infrastructure and constructing new infrastructure within those areas.
Mm.
And so I was wondering about that from your perspective, whether, given that, as you've clarified that there is we've adopted a hierarchy approach here, and there is a clear avoidance directive. So should that be reflected in a higher protection threshold, I guess, in relation to the establishment of new infrastructure within these areas?
Yeah, I'm just going back to policy 26 of the RPS to help with that answer, Commissioner Palmare, where the policy explanation details what an appropriate use and development of an outstanding natural feature and landscape is.
Yeah.
How long's that RPS?
That's 2013.
So pre-King Salmon.
Mm.
So how much weight can you give an explanation that was written before the leading Supreme Court decision on that very question?
Mm.
Like
I
it might be different if it was the policy. It is the policy unless until it's changed, but an explanation.
Yeah, explanation I typically wouldn't put significant weight on. That they are always useful and they're there and intended to be useful, but it's certainly the way planning documents are written now, explanations have fallen by the wayside, and instead what was explanatory text is now typically included in the policy direction itself.
And the policy says that protect.
Yes.
Yes, and then says what an appropriate use is, and it talks about respects. So it's not intended to prevent change, whereas protect tends to now in the post King Salmon prevent change.
So having said to you, it's pretty strong. You've now got overlaid on that east-west saying that there is some wobble for infrastructure, but it's very
Strained.
It's very it's a very narrow pathway.
That's what my hands would be.
Vanishingly small, perhaps, but there is that potential.
Yes.
But going back to where the commissioner started, are you putting too much weight on that explanation, given that it's pre-King Salmon, in your recommendation to shift from protect to respect? That's the bottom line.
Oh no, yeah, it is. I'm aware of that.
And if you want to think about that and give us a considered response, it's a very complicated question. We've got all these overlapping Supreme Court decisions now,
and I might take some advice on that as well and discussions with
that might
council.
be prudent as
I
well.
think that's necessary. It's a little bit outside of my wheelhouse, so to speak, in terms of that reconciliation.
Thank you. And just one further quick question that you may be able to answer or want to give some further thought to is one that's sort of jumping out at me at the moment as I look at the words, that the activity is of a scale that protects or respects. Either one of those two just seems to me to raise the question of, well, what does that mean? How would that threshold be measured or interpreted?
I think that would have to be a question that's put to, in an application, a landscape specialist who would look at those values which are in the Schedule 10 of the plan and have been identified by a landscape specialist and answer it in that way. As opposed to a planning assessment. I think it really firmly is a landscape proposition that an expert in that field should answer. So it's trying to set up the framework for them to be able to do that.
I see. And is there enough detail in the provisions to ensure that would happen?
Yeah, I think so, given how the the plan works in terms of outstanding natural features and landscapes. Yeah.
Ka pai. There was one other question and it's just gone out of my mind. Okay. Oh, just in terms of the wording, I see that the scale has been used all the way through, but in I forget where I've seen it. Various policies, Trevor will know, where there's a threesome that's referred to. The
Character, intensity and scale.
Yeah, and scale. And so, when I was just wondering, you know, when we're talking about outstanding natural landscapes and features and things, which obviously are treasured for their landscape visual amenity values and things, would character not come into it? Or is that just inherent?
I think it's inherent because
Okay.
the values will include
Yeah.
character.
Yeah.
I'm trying to think of examples. from
But I'm
other
thinking about the character of course, of the infrastructure, the type of infrastructural
Well,
development.
I think that the character of the infrastructure is, I think it's the character of the landscape that the effect the infrastructure has on it, which is the proposition
Yeah.
as opposed to the character or the scale of,
Mm.
or the character of the infrastructure itself. And the appropriate-
Structure will also be relevant to the need for it to be in that location.
That's
Yeah,
right, that functional and operational need, which is
Yes, that's right.
policy.
Yeah. But I mean, the character of some infrastructure might be underground, and so it's not going to have much of an impact
That's-
on an outstanding natural landscape.
That's
you know.
right, yeah.
But if it's above ground, it probably
Yeah.
will.
Very large, but underground.
Yes, exactly. So
Well, it
yeah.
could be
Anyway, I mean,
Very, very large, like Mount Coco's aerial, and yeah, so there,
ka pai.
yeah.
I think
Commi-
I've exhausted that one. Thank you.
Commissioner Black, before we come back to you, Mr. McMahon.
Mine's a fairly quick one. In about 256 roughly, you've got it's earthworks, INF, NFL, S21 earthworks, matters raised by submitters. You've got retain to the Wakate transfer, amend first gas Greater Wellington, and then there's no assessment.
Oh, yeah.
That's an oversight, Commissioner Black. Just bear with me a second, please.
So perhaps you could just do one and come back to us.
Yeah, I think I absolutely need to do that.
Like rather than making it up on the spot.
Yeah, don't know.
Yeah, I'm just trying to work out if there was a reason
Yeah, it might fall
why
off
by
them.
looking, but it's disappeared.
Yeah, fallen off.
So if you could add that in reply for the completeness of our record, please. Commissioner McMahon, you were chatting a little bit.
Yeah, nothing significant. I don't think it is. I'm looking at the architecture, Mr. Anderson, of what's now P38 and P42. And I noticed in P38 you've added an and an or, an and after one and an or after two. Previously there was none of that, and they probably were all ands, I imagine, given that the and after three is there. I just wonder what the significance of that is.
So
So which one was that prior?
the-
38?
That's in the new,
upgrade,
so the way I read that is subclause 1 of 38 presumably applies to everything.
yes,
2 applies to outside the coastal environment. And 3 applies to
Inside.
within,
yeah.
and what is 4?
4 applies to everything.
Yeah, or yes, I thought that was the intent, but you could also read it that it applies to just within.
Like if
Yes.
like should there actually be a 2A and
Yes.
2A or 2B?
I just wondered whether that splitting that into 2 parts might be a more effective way of writing the rule.
Yeah, it is. I can see.
Yeah.
how that confusion could arise. But it's certainly 1 and 4 to apply.
Have a think
To
about
everything.
it, but also have a think about presumably the same, presumably P42 is completely different because it's dealing with everything outside, isn't it?
Yes.
Coastal environment. So you don't need to make that distinction. And they're presumably all lands by default, 1, 2, and 3. It must be because it goes 1, 2, and 3.
Yes.
I think that the latter is the style of the plan where a conjunction after the penultimate means it's the conjunction that applies to the whole show.
Yeah, that,
Great. As I said, I think P42 is clear.
yeah.
I'm reading the fact that Mr. Anderson and I can read subclause 4 differently.
Yeah, because you read 3, if located within the coastal environment, any adverse effects on the identified values can be avoided, and there is a function.
You will recall from your profound study of algebra, Mr. Anderson, that is generally addressed by putting things in brackets.
Yes.
Whereas the in text, breaking it up would solve that problem.
Yeah, it's been a long time since I've looked at bed maths.
Just out of interest, Stanson, were those recommended changes of and or, did they come from the submitter?
Clause 16 change to try and provide some better intent, which hasn't come through because it's trying to split those. The or is trying to split that in or outside of the coastal environment, but it's confused things in terms of the and that then goes on for subclause 4. So, Thank you.
A quick follow-up question. I've just noticed that there's some inconsistency in the use of wording between those 2 policies, 38 and 42, and that I think in the policy 38 it refers to adverse effects or whatever it is can be avoided, as opposed to are avoided in policy 42. And I just wondered whether that was intentional or not.
Add significant adverse effects on identified values can be avoided. Can be avoided.
So
Are avoided.
policy 38 under 2, for instance.
Yeah, I'm with you. I'm just sort of playing it through in my mind.
Yeah.
I can't think of any reason why they are.
I should draw your attention to the fact that we picked up on this in our it was report 2A in the context of residential zones rules that talked about compliance standards can be achieved, and suggested that it should be the possibility of their being achieved was not the point, it was whether they were going to be achieved. And suggested a global change from can to are. And I was going to ask you whether the same issue needed consideration in the context of these policies. I hadn't picked up on the difference the commissioners identified, but as a general issue, talking about whether things can happen as opposed to whether they will happen.
Yes. That's the latter that I think is my preferred.
When the intent of the policy is testing whether something will occur.
Yeah.
So I wonder if we should ask you to do a global search for the word can and how it's used in context. And we then have an issue about whether is that a minor change, given that that's the intention, or such that it can be done without submission, or whether it's a general issue that we need to draw to the council's attention that needs to be tidied up in the fullness of time.
I will come back to you on that. Thank you, Mr. Robinson.
Any more on natural features and landscapes? So what are we up to next? Hazards. Um, (288). I wondered if your response was actually addressing Centreport's mission, which is it's not seeking a cross-reference to the natural hazard chapter. It's seeking that everything be in the natural hazard chapter. So, as I say, it doesn't seem to answer the point.
The Centreport Special Purpose Port Zone is excluded from the rule for operational port activities.
Well, I suppose, like your summary of its submission is that the natural infrastructure natural hazard provisions are located within the natural hazard chapter. Saying that they don't need to cross-reference the natural hazard chapter doesn't answer whether that is a good or a bad idea. And that's my question.
Seeking to avoid that overlap in the plan, having two rules addressing the same matter. Can I just confirm the paragraph reference you were talking to?
It's 268.
268. Sorry, I'm at 288, but I think it's the same.
That might have been me.
Same matter.
No. All right, it's the juxtaposition between 266 and 268.
Yes, yes. So I don't think it is appropriate to have the infrastructure natural hazard provisions located within the natural hazards chapter because of the direction that's provided under the national planning standards that infrastructure provisions should be standalone. The port, in some respects, muddies the waters on this because the national planning standards, as we talked about earlier, have the special purpose port zone rules, but I don't think that it's appropriate for all infrastructure then to have recourse to the natural hazards.
Thank you.
Chapter.
The dealing with Wiles submissions on, what are we up to? P61. They've sought do not recommend amendments, no certainty as to what an intolerable risk is. Another answer is that the CPS directs no increase in coastal hazard risk, which I think my colleagues addressed in report 4A or 4B. Sorry, looking at the wrong person.
I'm usually the oracle.
Yeah, but as I say, that's another reason that would support that conclusion.
Yes.
You may, I think I wrote some notes. You may have addressed this. R58, your response saying that the rule achieves what PowerCo was seeking. Have you come back to that in rebuttal and shifted position? I've forgotten.
R58, I've come back to around the underground infrastructure.
Yes.
Instead,
so-
other than maintenance and upgrading of infrastructure in legal
So
road
you've updated that view. We'll come back to
or
that.
customer connections.
Okay. Anything else on natural hazards team? We're up to other overlays. My question is about your recommendation. First question relates to Rule 62 on, so paragraph 317. The
Yes.
number B, sub rule B, saying does not involve earthworks on ground previously undisturbed by the infrastructure. What about if it's been disturbed by some other infrastructure? Why would that not be permitted? What does it matter? What sort of infrastructure has disturbed the ground? Isn't the point that it's been disturbed?
Yes, it is the point. You know, it's the words by the infrastructure.
Or just buy infrastructure. Take out the there and just delete it.
Yeah, I'm thinking, and we'll verbalise briefly, but if does it have to be then necessarily related to infrastructure? What if it's been disturbed by some other activity?
Well, normally our role to ask the questions.
I'll take
that as a rhetorical question. But I think it is. I think you have a point, and something perhaps you need to. You come at the logical consequences. What does it matter what's disturbed it as long as it's being disturbed?
Yes, thank you.
So you may have addressed this in rebuttal. I have a recollection of you discussing this. It's the or in this. I was thinking that it'll clearly be a chocolate fish. All present.
Could have been more if it wasn't such a good song.
I better hurriedly turn my own on silent now. does or between all of these in Rule 62 work? Because like the note I wrote myself in the margin was I could envisage that you then, because it's or, you could have a customer connection. It's not on an archaeological site, but it is in a root zone, and it's permitted.
Mm. Yeah, I think the issue could be if you're in more than one of the other overlays with an or, and how they do you only pick one or the other of those provisions, but otherwise the or is an appropriate
So
conjunction.
So that it's a problem in part.
Mm.
So I think it's just in the requires further thought category.
Yes.
The in relation to Rule 63,
Above ground customer connection.
above and other overlays, I'm thinking point that Mr. Kelly was pursued in his evidence that saying customer connections to heritage buildings are a controlled activity, given that they can affect the heritage value contributing to a heritage building being listed.
Yes.
You could equally consider by the same logic saying, well, above ground customer connection lines can affect the heritage values of the heritage area.
Yes, you do.
So why are you differentiating?
Because heritage areas aren't solely comprised of heritage buildings and have heritage buildings within the heritage areas. So for instance, the Courtney Place heritage area has a number of heritage buildings, say for instance along Tory Street and Wakefield Street, and it also has a couple of non-heritage listed buildings within that heritage area, and including
So effectively saying a customer connection of a non-heritage building in a heritage area does not affect
the overall
the heritage values of the heritage area.
In my view, yes.
The next question is, are you qualified to give us that view, given that's a heritage view and you're contradicting a heritage specialist?
I'm not qualified to give a view from that perspective. But in terms of my sort of broader appreciation of what a heritage area is, I'm looking at buildings such as the building that Panhead, for instance, is in on the corner of Tory and Wakefield Street, which is clearly not a heritage building, but is within a heritage area, and wondering under a Section 32 assessment why, if that building wanted to connect to, say, a new gas infrastructure for its kitchen, why that should require a resource consent when the building across the road, which is equally as modern but outside of the heritage area, doesn't.
We'll ask Mr. Kelly that question too. Now, 63 is about new customer connection lines. 65 is upgrading of existing above ground infrastructure.
Yes.
Same question. Can we be confident that upgrading of existing above ground infrastructure in a heritage area won't adversely affect values of the heritage area?
Again, and I've managed to do it this time, have recourse to INF S4, which has limitations on what an upgrade can comprise of before it triggers a resource consent. It is dealing with an existing effect on that heritage area. So it's not introducing a new element per se, it's upgrading an existing element. And that was my planning reason as to why it's recognizing that there's already something there as opposed to introducing something new.
And in relation to the discussion in your rebuttal of this point, I just find your suggested new R57 paragraph 29 of your rebuttal.
Yes.
And this is about like electricity cabinets in the road reserve. The question in the context of heritage areas is that the rules in heritage areas, there is a height limit of 1.5 metres. Have you considered the consistency of what you're recommending in the road reserve of heritage area with what's in the heritage area provisions?
No, I haven't. I'm trying to think. I've looked at some of the heritage area provisions and what the height limits are, and there can be ranges. But I wasn't across the 1.5 metre permitted limit.
Well, I think again, I think that's something that you ought to consider.
Yes.
And anyone else have any questions about the other overlays provisions? Mara?
Good on, Mr. Anderson. Where was I? Oh, yes. Just a few questions for you in relation to the INF-OL P62, Policy 62, Adverse Effects of Infrastructure on Historic Heritage, etc. And going to your paragraph 302, where you consider Transpower's request that the term give priority may give rise to interpretation issues, and therefore they're seeking that it be replaced with seek. My interpretation of that would be that seek may also give rise to interpretation issues. I mean, how do you determine whether there has been sufficient effort made, I guess.
How hard do you need to seek?
Yeah, how hard do you need to seek? So I'm just wondering whether replacing the original terminology with seek may in fact not resolve the issue of interpretation problems.
So what provision are we looking at?
Oh, sorry, this is provision OL P62.
P62. Gotcha. Thank
And
you.
P57 through the changes. Adverse effects of infrastructure. So I haven't included seek in my.
I think that
In your rebuttal, was it, or let me just.
I think I've mentioned it in the.
Yeah.
actually, sorry, I'm not sure that you did pick that submission point up and adopt it yourself. You're right.
That Transpower thought that the term give priority may give rise to interpretation
Yes.
issues and seeks that it be replaced with seek.
That's right.
But I've said
But you,
no. The framework set up to create an avoid regime in the first instance and then amend a remedy or mitigate approach if avoidance is not achievable. But I did consider that the word possible should be replaced by practicable, given
Yes.
that it's
yes. So
practicable is a better understood term and recognises matters such as expense.
well, let's come back to that one. And I mean, just in terms of that initial issue, then, just to be clear, so you haven't sought to adopt that request from
No,
Transpower. So
still give priority.
give priority.
to avoiding the
Okay.
adverse effects of.
Well, okay. So in terms of giving priority to avoiding the adverse effects of substantial upgrades, how would that be
I would
determined?
expect if I was an applicant using that policy, I would be going through a robust, almost like a multi-criteria analysis as
Right.
to how that effect can be avoided to say, look, this is the steps we've taken to avoid. However, it's not achievable for reasons A, B, or C. However, therefore, so that's the practicability
see.
aspect.
Yeah.
And then it becomes into the part B of the proposal. So it's to encourage applicants to look to avoid in the first instance, but recognising that this isn't always going to be achievable. And then it comes back to the direction around there's beneficial uses of infrastructure as well, and that it plays a part in everyday life. So
Yes,
it's
I
hard to.
understand
yeah.
where you're coming from. But doesn't the policy hierarchy framework or the hierarchy framework provide for that anyway? I mean, if it's not possible to avoid those adverse effects, then there is a default clause, if you like, which takes you back to determining whether the upgrade is appropriate or not, in accordance with policy 6, which seems to be a really wide-ranging and enabling
That is enabling.
policy.
Yeah, it's intentionally enabling the
Yeah.
benefits. But avoid, remedy, or mitigate gives 3 options, whereas I'm trying to emphasise the requirement to avoid in the first instance. That's the tack.
Yes.
I want the infrastructure companies to be going
To
down
avoid in the
first,
first instance.
and then recognising that that's not always possible, and having that explained as to why it's not, then moving on to that part B with the remedy, mitigate, and looking at policy 6, because the infrastructure plays an important role.
Okay, I understand where you're coming from. I'm just not sure that by using I guess it's a little bit like what we were discussing before in terms of adverse effects can be avoided, but that doesn't necessarily mean that the intention is to avoid them. If you see what I mean. So giving priority to avoiding doesn't necessarily achieve that, and I just wonder whether the signal is strong enough to achieve what you're wanting to achieve through this policy, and ensuring that there is avoidance in the first instance.
Yeah.
Okay.
Well, is the reality, what you're saying is that infrastructure providers need to justify why they're not avoiding the effect.
That's right. Yes.
And whether the policy should say that.
Right.
Yes, it's a bit more directive. So.
But it goes to your point, which is you want a proper analysis. Rather than the once over lightly. We thought about this and decided we couldn't do it. There's then the question about whether there's scope to change it to that extent, but
Right.
put that, that hasn't, that doesn't go away, but if you could address the merits of that
Yes,
first,
Mm,
and we'll go from there.
yes,
will do. Thank you.
no problem. And just sort of, oh, sorry, did you want? Just a follow-up question. It's on the same policy, but the second part of it to do with the practicable term and use of the term instead of possible. And again, it goes back to the intent of the policy to avoid in the first instance. And I just wonder whether practicable actually achieves that, because I mean, my understanding of avoid is irrespective of cost. You know, avoid in the first instance, irrespective of cost. Would that be your interpretation, or?
I think the practicability aspect's necessary for infrastructure, and again, it's
Mm.
having recourse back to the
Yes.
higher order
Documents.
and
Yeah.
the strategic objectives of the plan. So
Mm.
it's trying to set up that robust test that ideally, no, we don't want these upgrades to occur, so avoid in the first instance, but trying to recognise that that's not always going to be practicable. Possible, and in light of what that infrastructure provides for society. So I think going back to Mr. Robinson's point earlier, that engineers typically think anything's possible. The practicable aspect of it recognises that there are cost constraints,
Yes. Yes.
and so I think that is important
Mm.
as well. You know, when it comes back to part A of the policy, give priority to avoiding, I think ideally infrastructure providers should be looking at possibly relocating the infrastructure out of, and if there's any,
Right.
but then it might not be practical to do so because if the infrastructure has been in that location for a significant period of time, it might have a role to play that
Yeah.
means it can't be moved, or
Mm.
technical, operational, or functional reasons
Yeah.
as to
Yeah.
why it must be in that location and why the upgrade must
So where
occur
infrastructure
there.
is involved,
So,
there is a
I
justification
think,
for.
yeah, my interpretation of the higher order documents is that the benefits of infrastructure
Mm.
must play a
Yeah.
role in the consideration of
Mm.
effects of the infrastructure.
Mm. Thank you for that explanation. It was just that in your assessment, that you hadn't provided the explanation as fully as that, and you just sort of referred to what's possible is not always practicable. And I thought, well, is that a requirement? Is there a requirement for, you know, what's possible to always be practicable?
Yeah.
And that was didn't make sense. So thank you for that
No problem.
explanation. That's really helpful. Yeah, I think those are my questions in that
Commissioner
regard.
Fleck?
Hilda.
Thank you.
Just a quick one. In the old R65, now 56, your paragraph 328, this is just a editorial matter, this one. There is a mistake, and but it hasn't been corrected in the appendix A of your supplementary either. So the correction should be under the permitted. Infrastructures located on the site identified any of the following schedules as permitted. You've got category A of schedule 7, but your report says it should actually read category C, because category A is a restricted discretionary.
Yes.
So if you could just edit that. Just while I'm there, the other one point that just was following on from the chair's comment on that Mr. Kelly's submission is that it's relevant here as well. He's raised a point in this section. So your consideration, I think, of the heritage area provisions in respect of these matters would be useful.
Yeah.
Because he's referred to this one as.
Yes.
Yeah.
Yes. No.
So I think just look at the heritage area provisions would be helpful.
Will do.
Thanks.
I want to go Want to leave the national grid to last, and so the exciting bit at the end. I wrote some additional notes on your rebuttal, and I just want to make sure we picked them up.
Sure.
Your recommendation at paragraph 21, the additional words you've inserted, other than the maintenance, upgrading of infrastructure in legal road or customer connections,
Mhm.
should that qualify both B and C? Because putting them into one implies that it doesn't, that qualification doesn't apply to
Yes,
C.
I think C's more enabling. And that I think C provides for it in any instance because the city centre zone is the qualifier rather than.
Well, maybe you could think about reconfiguring it and put the other than at the start of, make it B, other than the maintenance of upgrading, etc., Indian 1, it's not located within the high hazard area, or 2, if it is, it's also within the city centre.
Yeah, I'll ponder that and come up with some revised wording.
Oh yes, EV charging stations.
Yes.
It's a personal disclosure. I have what is defined to be an EV charging station in my garage. And should this definition relate to commercial operations?
Where does that then leave? I'm just asking the question of myself here, the likes of private charging stations in terms of does the plan explicitly provide for them? The intent of including this in the rule is to make it explicit that charging stations up to that size specified under INF S7 are permitted in legal road and in private sites. So whether that be a residential garage or a park, open space type zoning park, or on the forecourt of a Z Energy station, for instance, on Taranaki Street. It's intended to capture all of them, and that's done to ensure that there is a permitted standard for all, and there's no ambiguity in the plan.
And I suppose you would assume that anything in someone's garage is certainly going to meet any permitted activity standard for what's on a garage forecourt.
Yes, and I'm pretty certain, I'll just have to have recourse back to the rules, that infrastructure within existing buildings is a permitted activity in any instance.
Yes, because I suggest you think about that, because this could, although this is intended to be an infrastructure provision by a side wind, you could be making private provision of infrastructure. So, for instance, one I've got's probably 1.8 meters in the air on the garage wall. So if there's a height limit, then
Is it external to the garage?
Well, that's, no, it's within the garage. And so, as you say, if your research indicates that anything within a structure is fine, then that answers that question.
But if it's
I'm
external,
just contemplating that to be an own goal to create an issue which doesn't currently exist.
May I speak as well on this
Oh,
one?
certainly.
I know this is
Any contributions are welcome.
also because these related submissions got caught up in the transport chapter as well. It was one that we both addressed in our respective 42A reports. And yeah, I did actually consider your thought about how would this apply to residential. And so I did take a look at the standards and thought, yes, these standards should apply to residential as well. So if someone has a residential charger that happens to be above 3.5 meters or has a large energy storage battery within two meters of a property boundary that could explode or have a fire risk, or is subject to significant radio frequency, then that's something that should also apply. So yeah.
What's a large storage battery for this purpose?
outside of V7.
Yeah.
Like I'm thinking of those big Tesla ones that solar generators, people with home solar put in their garage.
Yeah.
Like I had a friend who had one in Wanaka, because if it's within 2 meters of the boundary, typically if the garage is on the edge of the side yard, and of course the council decisions indicate there may not be a side yard in the IPI decisions, you might find that those kind of batteries, and people won't even think about it because they're inside.
So with 3.5 meters in height and 20 square meters footprint is.
Well, I think it's safe to assume a domestic battery won't be more than 20 square meters.
I hope not. Someone's making a little bit of a kickback if they are.
Yes, well, there's supplying half the neighbourhood if they are.
So is this indicating that the matter is not just an amenity issue, there's also a health and safety component to it as well?
Well, it must comply with the health and safety standards as well. Whether or not, I can't answer if there is a risk.
Is there a need for the district plan to cover anything other than amenity? So if the charging station is internal to a garage, does it really matter what the dimensions are?
But it shouldn't, and it doesn't, because if it's captured by the definition of infrastructure, and infrastructure within buildings is expressly permitted under the plan.
That's the answer then. Yeah.
Take you to your recommendation to accept Ms. O'Sullivan's wording to the infrastructure, the introduction of the infrastructure chapter, which has the effect that in the the objectives and policies of the infrastructure chapter apply to the airport, the port, and REG, but not the rules. The question is where there is an overlap between the objectives and policies of the infrastructure chapter and those sub-chapters, which prevails, and should that, if you're going to have that overlap, should the introduction say which prevails?
I don't know what weight would be placed on an introduction saying which prevails. I think that would need to be weighed up by a decision maker. Probably it's akin to explanatory text in some ways.
Well,
Although it's directive for,
in that case,
yeah.
should something more definite. Well, I suppose if you go down that track, what's the weight of this whole paragraph?
I know, I'm questioning that myself. I'm going to have to ponder this, Mr. Robinson.
Just another quick question from me that's come to mind in relation to the previous question. I just want to first of all clarify that the overlays subchapter also applies to the National Grid subchapter. That's correct, isn't it?
Yes, they do
They do,
cross-reference.
yeah.
Yeah.
And so in terms of the interrelationship and applicability of those two subchapters, if there is a conflict or inconsistency in terms of the provisions, which would prevail?
From a National Grid stance, given that the National Grid subchapter is being drafted to directly align with the National Planning Standard,
Yeah.
then
That would
prevail.
Thank you.
And I think the plan says that in as much words, doesn't it?
Yes.
In relation to chapters and subchapters.
Yes.
You quoted it earlier this morning.
Yes, I've explained
Yeah.
it. You're talking about the cross. Yeah, I'm going through the higher order documents in my mind here, Mr. Robinson, regarding your point of view, which is where I agreed with Ms. O'Sullivan. So I will come back.
Okay. Now, I'll come back to the detail of what's in the National Grid subchapter. But I'm reading paragraph 112. It's clear the National Grid subchapter does not specifically provide for any new underground infrastructure access tracks, funeral structures, new lines which are outside the coastal environment. My question is, well, should it? If you're going to have a National Grid chapter, shouldn't it be complete, or as complete as you can make it?
It should be as complete as it can be. And hence why I've considered it appropriate that those rules in the infrastructure chapter itself are directly relevant to the policies in the National Grid subchapter for National Grid related activities.
So but in terms of structure, should the National Grid subchapter should it provide for new structures, new infrastructure, or is this?
I don't think,
or is this new underground infrastructure, etc., that does not form part of the National Grid?
it can be both.
Right. Let's just say new stuff that's part of the National Grid. Why wouldn't it be in the National Grid subchapter?
I've thought about this as well and gone to and fro on it. It intuitively should be, but when the effects of undergrounding are no different in that National Grid yard than what the effects are of undergrounding a water pipe, I don't think there's a need for two different rules which essentially cover exactly the same activity. It's just where that is undertaken in the National Grid yards, then those policies in the National Grid subchapter should apply.
Right. Okay, turning to the National Grid subchapter, the general issue I have with this, and I accept that you understand that you've accepted Ms. Whitney's submissions in this regard and her suggested relief, is that these provisions don't line up with the NPSET.
My take on it is that,
What's
they,
that?
they do.
The answer, well, and that's the thrust of where I'm coming from. It's to the extent that they don't, why don't they, and should they?
They should. I've taken Miss Whitney's expertise and my knowledge of.
I was going to say that you had accepted her blandishments, marketing the effect of the NPSET, and clearly she knows it backwards.
Yes.
And because I've discussed it a number of times with her.
Yeah, I've seen her discuss it a number of times with many commissioners.
Yes. So you start with the objective. So the NPSET objectives are to recognise the national significance, etc., while managing the adverse effects and managing the adverse effects of the network and managing the adverse effects of other activities on the network. And I'm thinking, where did protected and provided come from?
Yes.
So we have a policy 58. Down. So we have enable the operation, maintenance and upgrade of the existing national grid and establish of new transmission resources. And I read policy 5, the NPSET, enable reasonable operational maintenance and minor upgrade of existing assets. So this would seem to go quite a bit further. And then policy 7, minimise adverse effects on urban amenity and avoid effects of the national grid on town centres, none of which seem to be captured in this policy. I read email. And then paragraph policy 61. Avoiding buildings and structures that may directly affect or otherwise compromise the national grid. Policy 10 of the NPSET is prefaced by the words, to the extent reasonably possible.
Yes.
And we're saying only allowing subdivision that the national grid will not be compromised, taking into account the ability for continued reasonable access to existing transmission access. So the question is, well, if someone puts a box in a place that's inconvenient for the access to the national grid, is that an environmental effect? Or is that a problem that because Transpower's property rights are not complete, they don't have an easement?
It's possibly the latter.
And so then in policy 63, in urban areas, development should minimise adverse effects on urban amenity. It should avoid material adverse effects on commercial and mixed-use zones. The word material is not in policy 7 of the NPSET.
No, it's just avoid adverse effects on.
And so I of course am going to ask Ms. Whitney all of these questions, and no doubt she will have an answer to them all. But the question for you to ponder is whether these provisions should be more closely aligned with the NPSET.
Yes, and I'll look forward to hearing Ms. Whitney's reasoning. Obviously, I've relied on her expertise with the NPSET, and I will listen in the context of what you've just put to me, Mr. Robinson.
Does anyone else have any issues on the national grid? Now, does anyone else have any more questions of any kind? Go for it.
It's that question on the reverse sensitivity, but we raised that before. That's the issue with Transpower and the,
Yes.
yeah, okay,
Yes.
yeah,
So that
that's it.
following the NPSET as opposed to the RPS.
Mr. Anderson, this is a sort of a big picture question, if you like, and it's prompted from your speaking notes where you usefully took us back to the strategic objectives of the plan that were issued as part of the IPOA bundle,
Yes.
and in particular SCA 01 and SCA 02. And the theme that you've highlighted for the panel is the need to enable establishment of infrastructure and its upgrading and maintenance to do a number of things, including provide for future growth and development, such that it's supported and can be sufficiently serviced, that is its growth, and that that in terms of development capacity, that the infrastructure is capable of supporting a significant increase in development capacity for the city. And then at paragraph 5, you've said, given that clear direction from those higher order strategic objectives, it's important that infrastructure provisions are capable of supporting the decisions of the council on the IPI.
Yes.
And of course, the decisions of the council have enabled more capacity than what was recommended by the panel.
That's right. That's why I've chosen those words. In
Yes.
Speaking notes.
Yes, and I thought that you'd chosen the words carefully. So my question to you is, have you had the opportunity, or do you think there's a need for the opportunity to go back and consider whether that additional increase in development capacity that's provided by the council decisions and ultimately the minister's decision works in terms of the enabling provisions of infrastructure in the plan? Is there, I mean, the issue is here one of integrated planning, and do you think the enabling provisions of infrastructure go hand in hand with what's been enabled in terms of housing and business capacity?
Yeah, I think they do. And the reason for that is regardless of what the capacity decision has been. So we've got, I'm not quite sure how to articulate it, but it's a comparative for the infrastructure. So if we've enabled 80,000 houses, we need to enable the infrastructure for 80,000 houses and whatever the subsequent business development is. If it was the equivalent of 40,000 houses that was enabled, then that's what the infrastructure would be. But there's no specific numerical value per se. It is about ensuring there is that integration between the development that occurs and the infrastructure that's needed to support it. So
Yes.
that's where I'd land on that.
Okay, no, thank you. I suspected that might be your answer.
Well, just picking up, if I understand your answer correctly, it is effectively you can allow all the capacity in the world, but the demand's the demand, and it's the demand that you've got to provide capacity for.
That's what I was. Yes.
The follow-up question is that while that's true in a macro sense across the city,
Yep.
Of course, the council decisions have a spatial component.
Which was my next question.
And sorry, all right.
You go.
And so they are providing capacity, greater capacity in different areas, mainly in the city, but also in the Nio-Kandala Valley. And the question is, do the provisions of the infrastructure chapter reflect that spatial element?
I think they do, and particularly through the upgrade provisions that we've discussed. I think it's necessary that we don't exactly specify where the infrastructure I've talked about it being on a district-wide basis intentionally, so that there is that opportunity for infrastructure to react or be proactive for growth, whether that be greenfield or brownfield, regardless of where in the city it is located, with the obvious caveat of if the growth's occurring in overlays, there's provision through those overlays subchapters in the plan to infrastructure subchapters to accommodate. But I wouldn't anticipate that that's where the growth would necessarily occur.
Sorry, Commissioner.
No, that's fine.
Yeah.
To paraphrase, are you saying as long as the framework is at the right level, then that's the answer? Even though the framework might be on a district-wide basis, it's the individual spatially who should be capable of taking advantage of it.
That's right. Yes. Yeah. I think it has to be like that.
Yes. I mean, I was in a hearing a couple of years ago for a retirement village in Karori. One of the limiting factors there was water supply.
Yes.
And I guess that requires an investment either by the council or through the development community at the time of development. Regardless of who does it, the question that we've got is that are the provisions appropriate to enable that sort of development to occur where there's increased residential activity such as a retirement village?
Yes, I think that what the plan can control in terms of enabling that is appropriate.
Yes.
And it is trying to encourage and recognise and support that level of investment. The question of infrastructure investment obviously sits outside of the district plan and necessarily so is a much bigger question that.
Interestingly enough, in that example, that consent is about to be surrendered.
I've seen that.
One, not the only reason, relates to servicing challenges.
Yep.
One of the reasons given by the proponent. Yes.
But servicing challenges presumably from an expense as opposed to necessarily a RMA. I'm not across it, no.
I think servicing challenges in terms of the cost and timing of the necessary upgrades particularly to create sufficient quantity and pressure of water supply, which is particular to that Karori suburb.
Yeah. What I think the district plan needs to do and what I think it does do in this instance is when those decisions are made around funding, that the district plan provides appropriate control, isn't necessarily a barrier, so that those upgrades can happen to ensure that integration between the land use and infrastructure as.
Yes.
Yeah.
So that's local government act processes in terms of the long-term plan.
Yes, that's right.
Development contributions.
And however else the new government's indicated they might be looking at funding that.
Okay, that's been useful.
Thank you. Any more commissioners? Well, on that note, I think we'll adjourn for the day and think about transport matters. Well, I suppose I should ask Mr. Wharton that question for assuming. Would you like to proceed with transport, or would you like to hold it over until tomorrow? It's over to you. I think that we've got enough time tomorrow to deal with it, but the question is, well, we're here and hot to trot. We may need a fortifying coffee before we talk to you about transport, but are you ready to roll?
Yes, I am. However, there are two other expert witnesses that are planned before me tomorrow. One being the council's engineer talking about various road access and manoeuvring type things. So if you have particular questions on those areas, it may make more sense to wait and ask her first rather than asking me questions where I've relied on her evidence first. So I think it's perhaps, perhaps I could give a brief overview to start with.
Well, I wonder if let's do it that way. If we'll break for a cuppa, and then if you could give us an overview of your chapter, and we'll pick up any high-level general questions the panel may have on your report as a whole, and then we'll save the specifics until you've, as you say, you can call the technical witnesses you're relying on, and we can hear from them first.
That sounds sensible. Thank you, Chair.
Thank you. So we'll adjourn and be back at 3:45. Thank you very much for your contribution, Mr. Anderson. It's very much appreciated. As I say, very interesting discussion. We'll resume the hearing. Mr. Wharton, I think that having reflected on it, one of the commissioners pointed out to me that because you were on the hearing schedule is on tomorrow, there's the risk that people may not be dialed in who want to hear you. We'll hear your speaking notes and we'll then adjourn for the day and we'll crack into it in the morning. But this will give us an overview. So over to you.
Great. Thank you, Chair. Good afternoon. So I think you all know me by now. My name's Andrew Wharton. I am a team leader in the district plan team for Wellington City Council, which is a slightly different position than when I presented to you last year. I'm the reporting officer for the transport chapter. I'd like to just give you a brief introduction about the plan's transport provisions and some of the main questions and changes that submitters raised. The infrastructure chapter that you've just been through covers the transport infrastructure. So that's the things in the road corridor, rail corridor, other parts of the transport network. The transport chapter, on the other hand, covers the on-site transport facilities and movements. So my 42A report covers that and some more general transport topics and definitions as well. Kaingaora has asked for transport infrastructure provisions to be moved from infrastructure to transport. I've covered this in my 42A report and concluded, along with Tom here as well, that the division of the provisions between our two chapters are about right, except for the connections to roads provisions, which should be moved over. They are discrete and they match other similar transport rules about site access. I've assessed the transport submissions in my 42A report mainly on a topic basis. And that's because each rule kind of connects to standards and tables and figures and also links back to a specific policy, and they all link together. So I'll also raise here some main topics that I've covered in my 42A report and further evidence. I won't go through all of the topics today, as in my written evidence, but I assume that you will question me on them tomorrow. I have considered the Wellington Regional Policy Statement directions for transport. Greater Wellington Regional Council did ask for the new proposed RPS policies relating to climate change to be directive here. I've disagreed with this because of the stage they're at in the process. So the proposed district plan was notified before the RPS change 1. So it's something I do have to give regard to, but not to give effect. And these particular RPS provisions have been challenged significantly, including by the Wellington City Council. And the Greater Wellington Regional Council reporting officer also recommended significant changes to their content. Decisions are due pretty soon, so the directions might remain the same as notified, they might be rewritten, might be removed, and so I've given them a relatively low weight in my assessment. Those provisions in the RPS, the new proposed ones, were generally about reducing fossil fuel use. In principle, I've considered that these are more effectively done in plan provisions for urban form and enabling mode shift, rather than requiring each single activity to assess its own carbon reduction. Greenhouse gas emissions being a national environmental issue and mainly managed through national methods and directions, such as the ETS and national policies, but recognising that the district plan does have a role to play in reducing the barriers to change and enabling low carbon choices. So you'll see that kind of philosophy moving through my recommendations in my report. A number of submitters asked for council to do transport related things that were outside of the plan scope or that were best managed through the council's other processes or other parts of the proposed district plan. For example, a request to prioritise public transport on the road, provide more park and rides, do better signposting of access ways. I cover each of these topics in short in each of the in the 42A report, and I've recommended that they be addressed in the other processes or places. These terms of cycling and micromobility, and generally in the plan and in this chapter, they are treated more or less the same, and the standards are based on the needs of the bicycle, though a few micromobility options will need to have wider things such as mobility scooters, which is relevant when I talk about the retirement village and what they've asked for. Rules and standards for these generally had strong support. Submitters also wanted different parking numbers, better dimensions for cycle micromobility parks, and safer and better facilities. Stratum has provided further evidence supporting their request to remove these standards, or alternatively to reduce the number of cycle mobility parks required in the city centre zone. In general, I consider cycle parking as a key method to enable people to use active transport modes. It facilitates choice, helps lower carbon emissions, improves accessibility. My evidence supports Mr. Leesman's work on cycle park numbers and dimensions, which update the plan standards to align with the latest NZTA technical note on this. However, I have supported in part some of what Stratum have brought up, with some lower minimum numbers of cycle parks where it still enables mode shift and transport options over time, but recognises the unique situations for retirement villages and also in the city centre. I consider these revised standards are more efficient options to meet the policy goals. So a couple of submitters asked for lockers and showers to be required. These do seem to be a popular way to encourage cycling and mobility in the international and national literature. But after reading surveys specific to Wellington City, both by the Council and Aotearoa Bike Challenge, I was concerned how applicable that was to our unique climate and how much showers and lockers are already being provided by employers. So a Section 42A report does a Section 32AA type assessment and evaluates those options. And I do conclude by supporting a requirement for lockers and showers, which is also consistent with the council policy and the spatial plan, but only for new commercial tertiary healthcare buildings that will hit new parking thresholds. So basically quite large developments. And I anticipate most of these new developments provide these lockers and showers generally anyway. Some submissions covered electric car chargers and chargers for cycles and micromobility devices. The overall principle of the standards in this plan requiring these is about removing barriers to people to choose low carbon vehicles for the future. Developers don't have to provide on-site chargers, but they have to at least provide the electrical conduit to the car park area so that users can install their own charger and cable and meters. It's much cheaper to do this when the building is being built than having to drill through walls, dig trenches to retrofit. This also would put the burden of, if they had to retrofit, this would put the burden of cost on the first person to do the retrofit that others then could benefit from. Plus the cost of retrofitting is high. The council found that installing chargers on road and in car parks of community facilities, and this is just an example, costed around $20,000 just for the civil works around the charger. There were various opinions when resource consents with integrated traffic assessments for road access are needed. Evidence is tabled with you in favour of higher thresholds, similar to Auckland, Christchurch, Porou and Lower Hutt. There is no consistency of thresholds in national direction or among councils. It's both higher and lesser than WCC, although Wellington City Council is on the lower end. This lower end threshold is due to the level of assessment this council has needs or has asked for. Wellington City has steep roads, driveways, congested arterials, cycleways and walkways. The integrated traffic assessments for developments generating lots of car movements also helps show how the other transport standards are met as well. The assessment level of detail doesn't have to be extensive. It will depend on the degree of change, the location and the effect on local traffic, including cyclists and pedestrians. In terms of the access for fire engines, there were different points of view from Fire and Emergency New Zealand and submitters. Submitters raised the overlap with the Building Act requirements. I've reviewed the panel findings on this for the Porou proposed district plan as well, where there were similar arguments heard. I've generally supported standards for site access to enable fire trucks for when the buildings are far away from the road, about 70 metres, as this is generally a district plan function for communities to provide for health and safety. The Building Act starts applying for the fire vehicles parking and accessing to the building itself. Resource consents are able to consider if alternative firefighting options will work if the development can't meet these access standards. For example, quite a narrow driveway up a steep hill, as happens sometimes in Wellington. The On electric vehicle charging, the service stations have asked for specific rules to enable these, and they've been covered today as well. I've noted that there may well be national rules on this in the future, and for now I've joined Mr. Anderson in recommending this activity be added to INF R7 structures associated with infrastructure. And also to confirm that parking and manoeuvring also applies to electric vehicle charging, meaning if you're driving into say a service station that has that they would need to meet the same parking manoeuvring standards. I've aligned my advice with my transport engineers expert, Patricia Wood, and her advice on changes to vehicle parking, access, manoeuvring and loading bays within sites. We can answer more questions on these as needed, or depending on whether it needs more of an engineer's answer or a planner answer, or both. I've supported submissions to remove public notification in the few transport rules where it was still an option. And this is because I view transport rules as having a site-specific application requiring technical evidence, and they don't have wider adverse effects on the general public. And so I guess I'll be open to your questions now at this high level, and we can continue into the detail tomorrow.
Well, I think, as I say, we'll quit while we're here. Thank you very much, Mr. Wharton. As I understand it, you'll start with Ms. Wood and then Ms. Leeswin in the morning, and then we'll go from there.
That's great.
Thank you very much. And we'll adjourn for the day and be back at 9 a.m. tomorrow morning.